The scripture says, in him we live and move and have our being. Let us honor him and ask him to take his place in what we are about to do. He is our life. He is our Creator, the Almighty. He formed us in our mother's womb. He knew us before we came into the world. He knows the end from the beginning. He is our wisdom, our guide. He is our protector. He is our shepherd. He is our Father. He remains our Savior, our Redeemer, the one that came down as a human being and died for us and gave us life, even eternal life. He is the lawgiver, the just judge, the governor of the nations. He is the King of kings. He is the Lord of lords. He is the one whose kingdom is from everlasting to everlasting, whose dominion is forever and ever. He is the one that kills and makes alive. He is Alpha and Omega, the first and the last, the beginning and the end, the one that has the keys of hell and of death. Father, we honor you, our Creator, our God. We worship you. We thank you for this event. We thank you for keeping us, for bringing us here. We thank you for safety. We were here last year, and Lord, you kept us all, and you brought us again to this place. Our Father, we thank you. We give you thanks for every soul that is standing before you here. And we want to commit what we shall do into your hands. We are asking for your presence. We are asking that your Spirit will brood over us. In the mighty name of Jesus. Bless us. Let your light come forth. Let your law shine forth. In the mighty name of Jesus. Amen.
the pastor say amen at the end of the class. I mean, this is very outro, so, yes. Now, we're not sure this started, so I'm going to be inviting different functionaries to where's my usherette? Where's the lady? I need an usherette here, an usher, somebody. I was going to be volunteered, actually. Now, I'm not going to be, we made all the introductions in all the right order or protocol. So I might not follow some of those orders this, because for this occasion, the present party here is chairman. So I'd like to invite the chairman of this occasion, Honorable Justice J.E. Akaraiwe, JCE, Division, to sit at the table with us. Let's put your hands together. Let's follow this. You make that. Yes. Stay with me. Thank you. Thank you. I'm now going to invite, well, you know, the Honorable Attorney General is here in his own capacity in any case, except that he was told this morning, is only in a dual capacity. So he's also representing the able government of the state. I had some good words about the government when I was coming in, from the Uber driver. He said, "Our government is very good." Yeah, so he said. So yeah, that's what I heard. Please let us welcome Dr. Kingsley Tochi Uday, Honorable Attorney General. Please. Oh, come on. Help me. Help me. Thank you. Thank you. I hope not. I was informed, I hope rightly, that lunch was served. Sir, lunch was served? Oh, good. So it's open now. Clap an inspiration. I'd like to invite no, I'll keep it to the last. The discussants who are present here. Yes. Tochukwu Madika S.A.N., please. Representing Anthony Ani S.A.N. Yes. I know. I told you I was not going to follow the proper protocol. Oh, that's the other way. What did I say? Oh, sorry. Sorry. Yes. Anthony and S.A.N. represented by Tochukwu Madika S.A.N. Just put your hands together for Mr. Madika. Fidelis Madika S.A.N. not at the moment. Oh, Johnny. Oh, thank you, sir. You came in earlier. Oh, yeah, I saw. I thought I knew you were coming back. You're welcome, sir. Thank you so much. Put your hands together, please, for Mr. Fidelis Madika S.A.N. Mrs. Ifeoma Adara. She here? Oh, you're welcome. Clap for the lady. Clap for the lady. Ifeoma Adara. I'm trying to pronounce that properly, right? I did, thank you. And of course, the last discussant was first show here, Oyi Kosola Badejo Okusoya. Now, I didn't say Miss or Mrs. because I did that once and I was corrected, so. Let's go again, please, for Oyi Kosola Badejo Okusoya. This gentleman here, thank you. Sir, I'm looking at you. Sir, you, thank you. You've been very cooperative. Please, a clap, sometimes they clap, sometimes don't clap, but it's good. Thank you very much. Yes, thank you. Right, now I'm going to introduce our guest lecturer. Now this should, no, let's, where's the lecture? We'll do that. We'll do the recitation. Because you know our guest lecturer, Professor R.A.C.E. Achara. I want to know, I hope you tell us today, Prof. I will tell us today, or tell me today, as members of the know what R.A.C.E. stands for. We? Good, thank you. Yes, tell me. Before we do that, I'm going to call our chairman, Honorable Justice J. Cannon, JSE, for his welcome address. Welcome address, sir. Your welcome address, sir. Oh, your welcome address, sir.
Your Excellency, the Governor of Enugu State here, represented by the Honorable Attorney General, Dr. Ode. Did I get the Deputy Governor? Okay. Here represented by the Lady Governor. The Honorable President of the Customer Court of Appeal, my lords, serving and retired, senior counsel, I particularly acknowledge the doyen of the bar in Enugu State. You are welcome, sir. Ladies and gentlemen, let me welcome you to today's occasion and thank you for creating time to be here. But let me say from the outset that though we are members of the magistracy, you are welcome. Let me say from the outset that though we are a very conservative profession, that nature of our profession does not hinder us from clapping when we need to clap. So please, I'd like once again to clap for the members of this table. Thank you very much. When I was given the invitation by Senior Counsel Akaraiwe to chair this occasion, I had no hesitation whatsoever in accepting the invitation. And this is the reason. I hold the bar and the bench in Enugu State in very high esteem. This is because the standard of practice here is very high. Not only high, but also very challenging. As Justice of the Court of Appeal, I have to work very hard to keep pace with their submissions. And number two, I must also say that the standard of judgments that come from Enugu, the High Court here, is very high. It makes our work quite easy. You easily read and understand the thoughts and the flow of the thought of the judge. So that makes our job very easy. I'm not sure we've obtained, I think the ratio of reversal of judgment will be 1/10. So I commend the judges. The topic of this lecture is quite job-breaking. Per INCURIAM REAGITATA. Is it tata? However, in simple terms, the importance of the doctrine of stare decisis cannot be emphasized in the legal profession. It gives certainty to the law so that you can predict what the court is going to decide in any given situation reasonably well. It makes certainty in the law. However, the challenge arises when you find conflicting judgments of superior courts, whether the Court of Appeal and especially the Supreme Court.
which one do you follow? And I can tell you, with all due respect, that the rate of churning out of conflicting judgments and decisions is rising. Well, this may be attributable to our human nature, we are given to errors and all that. So the question always is, which one do you follow? If you have before you two conflicting judgments of the Supreme Court, and you are writing your judgment in the Court of Appeal, or the High Court, or the Constitutional Court of Appeal, or even as a magistrate, which one do you follow? It can be very, very challenging. Because you are working on a NIH. You follow one, and the matter rises to the Supreme Court, and they pillory you. Judicial impertinence, judicial abuse. So which one do you follow? There are many positions that have been given as to how to resolve such a matter, which direction to follow. Follow the latest one. Akaraiwe with college education. Follow anyone you want to follow, so long as you give your reasons. No, follow the one that was decided by the full bench. No. If the recent one makes no reference to the earlier one and does not distinguish it, then don't follow it because it was made by INCURIAM. So you are in a dilemma. And that's what we're going to look at this morning. Thankfully, the guest lecturer, Professor Achara, is well armed to dissect the topic. I'm sure by the end of the day, we'll go home satisfied, knowing what to do. So on this note, I welcome you to today's lecture. I ask that you please give your full attention and that you will be the better for it. So once again, ladies and gentlemen, you are welcome and God bless you.
Let me say it in straight language. You let it fall my hand. You are following my hand. Clap properly, please. In appreciation. It was brave, but targeted. Thank you. Thank you very much. So the next item in our program here is the recitation of a poem by Ode Eyoibo S.Y. So I'm calling on Ode Eyoibo to come and, oh, that's me. It says here a recitation. It's not a recitation, really. A recitation is a how come I don't have it? Oh, I'm the maker. Oh, right, okay. Right. Yes, I've just been informed that a copy of the poem is attached to the folders that you have. It's contained in the folder. So you can follow us, read along as we. So I said it's not a recitation, it's a reading. And when I saw the subject, I thought, yeah, should do some poetry to this. I remember when I was on campus here, we used to just go to the library to read law reports, to read Lord Denning, to read Salu Mbanefo, people like that, just because of the beauty of the language. It had nothing to do with the work we're doing, but I just liked the language. They deployed poetry, Shakespeare, did all sorts of things in their judgment, so it was wonderful. Anyway, so here we go. Per INCURIAM. A lapse in vigilance, not malice, but mere inadvertence, serves our fate. A kingdom lost for want of a single nail's weight. We must shed our worries, casting cares aside. Yet, in comparing cases, caution must be our guide. For in any case, abundance cotella, as we say, indeed similarities and similarities we must tread with care, lest negligence creep in, and our judgments be labeled criminally negligent. Our words, worthless as whispers. Our authority, but a dreamscape, a nightmare. Reaping the bitter harvest of disregard and disrespect. Our pronouncements hollow, lacking cordial weight, leaking reasoned substance, failing to anchor our words and relevant laws. Our judgments are held brittle, porous, fragile, without a binding force to hold and to mold. Per INCURIAM, a verdict that undermines our might, eroding authority, consistency, and the rule of light, the rule of law, the rule of just laws. Our process, a reed swaying in the wind sway, a lying thing of straw, devoid of substance, lost in disarray. Per INCURIAM, a lapse in vigilance, a failure of care. Yeah, I guess it was clap for me. Thank you. And now to the main event, the reason why we gathered here today, the lecture to be delivered by Professor R.A.C.E, Achara, PhD in Nigeria, and to be commented upon by a panel of discussants. Professor R.A.C.E, Achara. You're welcome to take your seat, sir. No, yes, just stand here and I'll read it. No, it's okay. It's okay. Just before you take your seat, sir. Professor R.A.C.E, Achara, PhD in Nigeria. Bill and Melinda Gates Foundation Fellow of the Five College African Scholars Program, University of Massachusetts, Amherst. A millennial chairman, NBA Indigo Branch, 2002, brackets, leading that most principled of branches to the end of the last millennium and to the start of the current one. His 2005, The Constitution as Junction of Force and Law, a re-examination of the current epistemological foundations of constitutional law study in Nigeria, proposes his doctrine of preponderant force as perhaps the presently most coherent analytic device for understanding the seminal thought antinomies underlying the persistent clashes of law with force. The doctrine of preponderant force. Sounds powerful already. And builds on his doctoral thesis, which won the University of Nigeria Postgraduate Prize for Law, a distinction first achieved in that premier Nigerian law faculty by the Honorable Professor Justice Nikki Toby, JSC. Primarily a practicing litigation lawyer, called to the bar in 1987, and professor of constitutional law from age 38 since 2004, so we know how old you are now. His writings and oral advocacy of the last quarter century increasingly demonstrate that our Supreme Court determines the consistency, coherence, and trustworthiness of justice in the polity, and consequently the dependability, prosperity, and flourishing of lawyers, whether in academia, litigation, bench or bar, or in transactional practice. Whether to honorable judges and other lawyers in Enugu, Nsukka, Oka, Makurdi, Anocha, Abakaliki, Owerri, Afro, Nnewi, Ado-Ekiti, Asaba, or at the NBA 2022 AGC held in Lagos. The thesis, especially impressed through its 2012 judicial flip-flops and theory deficit in the Supreme Court. Have Nigerian law faculties flunked their final exams? It's consistent, almost strident, unless we prioritize and focus reforms and curriculum change efforts to restoring and prioritizing the Supreme Court's capacity and philosophical attitudes regarding the coherence and rationality, imposition, rules for the judicial system, our hopes for a world-class justice delivery system were merely a hollow dream, propped on nothing more solid than ethical hypocrisy. That is Professor R.A.C.E. speaking. Achara was Dean of Law some 20 years ago at R.A.C.E. and also taught at two other universities, R.A.C.E. and the NAU, since 1994. Is currently the principal at the Professor R.A.C.E. Achara Law Chambers, New Haven, Enugu, and can be reached by email by acharace@yahoo.com. Please put your hands together for our guest lecturer, Professor R.A.C.E. Distinguished, keep clapping please, keep clapping please. Our distinguished guest lecturer, Professor R.A.C.E. Achara. Thank you, sir. Okay. I'll give you this one. We can just this one. This one here.
My Lord the Chairman, my Lord the President, my Lords, your worships, learned silk, my learned friends on the high table, well, there's no high table, the resource persons, the Honorable AG, both in his capacity as AG, the leader of the official bar, and in his capacity as the person I understand representing His Excellency. The leader of the bar, the chair of the bar, my lords, serving and retired, I don't know if I've missed out anything. My learned friends, distinguished ladies and gentlemen, I should like to start off by saying that I have a lot of people to say thank you to. The Akaraiwe and Associates, especially their past manager, head of chambers, who is now on the panel, the guests from out of jurisdiction, my learned friend, Oyintashola Badejo Okusa, I hope I didn't murder that. Silk Mbadoga, I've already spoken about Silk Tonyane, represented by Silk Tochukwu Madoka. I guess I've covered the bases. Now I can now have the opportunity to thank the bedrock for this beautiful idea of having series of lectures about areas that we might as litigation lawyers not have sufficient time to deal with. That is to say, Silk Akaraiwe and his lovely wife, Dr. Nkiru, the associate professor, and now professor. Aha! At last. I said the last time I introduced her as professor, and she corrected me, said I was still associate professor at the time. So I'm glad that what has taken so long, because she deserves this, has now arrived. So this is very good because it gives us an opportunity to look into areas of law that we would not otherwise, as litigation lawyers or judges or magistrates, have enough time to think about. And my Lord, the Chairman, has fully summarized the problems. In fact, if not for perhaps the fact that my name has been put on the list, I would have said that my job has been done. My Lord has fully characterized the problems. How do you deal with this issue? Now, I think that the best way to deal with this issue is by addressing it in 5 claims that I will make in this lecture. 5. The first 3 claims are the conceptual and historical backgrounds for the 4th claim, which is the focus, which is the problem my Lord raised. And then the 5th claim will be the conclusion, the suggestion of what I think is the cause of the problem and how I think we can solve it. The first claim I will make is that contrary to the general view of lawyers and judges, that the rule of law is something that is made to stop only the executive and the legislature. My claim is that no, it also applies to the judiciary itself. In fact, perhaps even more so to the judiciary. That's the first claim. The second claim I'll make is that the way we have developed the profession of law in its 3 major areas that deal with litigation, that is judgeship at its apex, meaning the justice of the Supreme Court, teaching of law, at the apex of which is the law professor, litigation practice in the courts, at the apex of which is the senior advocate of Nigeria. I'm saying that it is the evolution of this which is peculiar that can guarantee for us areas in which, or devices by which, we can address the problems of inconsistency and incoherence, which is the major part of this topic. The third claim I will make is that after getting the profession of law to satisfy the issue of rule of law, there are devices through which it has gone about limiting the possibility of inconsistency, incoherence, and caprice in judgments. There are 3 that I'll point out. First is in dealing with the personal issue of integrity of the adjudicator. The second is regarding the adjudicator's competence to be able to deal with the law he is supposed to administer and interpret. And finally, are the procedural rules that have been evolved to ensure that there are guardrails against excesses. Even a judge who knows the law, even a judge who is competent, sometimes can also be arbitrary, sometimes can make mistakes, sometimes can give judgments that go against the rule of law and protection of the citizen. Now, amongst these procedural rules, there are several of them. It is how we will now start narrowing it down. The focus we are going to call our attention to is the issue of stare decisis. That is, precedent, how to control judges so that their decisions, regardless of the personal capacity of individual judges, that at least it can be predictable. There should be rules guiding that. That is stare decisis. But then, and that is the fourth area, which is the focus of the lecture. My Lord has said, it's a mouthful. I'll blame it not on myself, but on Professor Julius Krohn, from whom I took inspiration for the title. That is RE.AGITATA. That was his article in 1939 in the Law Quarterly Review, volume 55 of at page 66. 25-page classical work that changed the way we framed our Evidence Act. In fact, when you look at our Evidence Act, you see that it's mostly the recommendations he made at that time that have come into being in what we now use as Evidence Act. But I didn't have the courage to stop at the three Latinisms he used in his own title. So I tried to at least build it up. So it's per INCURIAM RE.AGITATA. Now the re has a hyphen between it and agitata, so that when you do your Google search, it will be easier for you to see the meaning. Per INCURIAM, transliterated, means per, by. By means per. INCURIAM, carelessness. So decisions reached by carelessness. Re is again. Agitata is agitation in Latin or Italian. In Italian it's agitato. In Latin it's agitata. So what we're doing here is that we're going into the issues. That per INCURIAM is something, as my Lordship has pointed out, it's something we all know. But the problem is, how do we apply it? What are its features? What are the difficulties? And my Lord has brought those ones down. Now, at the start of the invitation for me to present this, I did ask for an understanding of what time will be available to me, because it helps in preparation. If I know I have enough time, then I can address the background, conceptual background in more detail, because that is what will help us decide what is the option we should take, as pointed out by my Lord the Chairman. But if we do not have enough time based on the exigencies of the particular occasion, for example, maybe the late attendance or maybe the number of those who will speak, then I will have to reduce, maybe just itemize the issues of background and then go straight into the core of the issue. But I think it's important to look at the background. You see, the issue of rule of law is all about constraining sovereign powers to law, to predetermined rules. That is the whole basis of rule of law. And if we agree that rule of law also applies to the judiciary, we'll see why and how it applies to the judiciary. You see, the way we developed the profession of law is a very important part of how to determine why we look at coherence, consistency, and predictability with such importance as we do. We really need to understand this background. First of all, understand that when we talk about a court judgment, there are actually two features. The first is justice for the immediate parties. And that you will find in res judicata. The thing has been decided. It applies strictly to the parties. But you see in many judgments, these are mixed up. They talk about res judicata in the same breath as they talk about stare decisis and precedents. But no, they are two different, they are nuanced. The next feature is for non-parties, the general society, and I think that's an even more important part of a court decision. That judgment that the court has given is supposed to be a guide, a model to future judges. And why is this so? We go back to why we said we have evolved in the rule of law to avoid caprice. There should be an understanding of what has been done before. I expect that if the judges said this yesterday, that it is likely that they will say the same thing tomorrow. Therefore, I can order my affairs as a normal member of society or as a litigation lawyer advising his clients or as a judge of a subordinate court that needs to look at judgments that has been made by another court superior to it. I should be able to know what has been done before and therefore know how to act in future. But originally, the judge used to be the king, the holder of sovereign power, or any dictator, or a junta of many such persons holding power. So you find that it is not inherent in a judgment that it should not be capricious. We need to understand this ideological basis. It's not inherent. In fact, it is expected if we use theological background. When God is giving his judgments, he does not rely on prior authority or precedent. And the kings of the olden times believed that they descended their authority from God himself. And therefore, they were entitled to give judgments in their wisdom. And they expect that perhaps tomorrow their wisdom will tell them that this is a better way to give this judgment. And then they give it. So, inherently, it is not an inherent feature of a judgment that it should be coherent, consistent, or follow prior decisions. But then, our profession developed in such a way that we have evolved away from this because we are trying to maintain rule of law and to ensure that we have consistency. It is important to bear this in mind. And that is why we have difficulties with judges that proceed on the basis of in fact, I have a brainwave that this is in the justice, in the interest of justice. It is probably going to be better for this person. The law that you are bringing to me, even though that is the previous decision, but because I believe it will cheat this person, I'm entitled to change it. That is the danger. In some instances, this will be possible that, yes, a previous judgment was not the best. And that judge who wants to give his own unilateral decision, his own judgment might actually, for the parties before him, be the best. But the danger in this is, what if every other judge acts that same way? We get back to square one. We get back to the kingly judge. We get back to the judge that does not adopt the rule of law. The judge that believes in caprice. And that is what we have to bear in mind. We have to bear in mind the disjunction between the king as judge
and the development of the professional judge. And you find that in virtually all the jurisdictions we have, including our local ones. But let us take our minds to where we borrowed our current system of justice in England. You see, that's how it started. It's not as if the white person is more in tune with coherence or lack of caprice than our judges. They also had their kingly judges. And the position of law was that these kingly judges, when cases became too, there are too many cases, the judges realized, as Moses' father-in-law realized when he was watching Moses. He said, look, you're going to kill yourself. Oh. You cannot be judging. I've noticed you judge from morning till night, standing up, judging. Is there a glass? Okay, thank you. You're going to have difficulties if you continue this way. So there was a delegation of judgeship to other persons. But these judges were merely officers of the king. And that's the origin of Privy Council. Privy Council is an executive body. It's the judicial committee of the Privy Council. You know? So it is, the Privy Council is the council of the king. So the king now delegated to other people who are, in his estimation, intelligent people in his executive to help him hear cases. And gradually, even for these delegated judges, it was found that cases still needed to be dealt with by other people. The dukes in their dukedoms, the lords in their various places of control, exercised direct power, capricious judgeship power. But it was found that this was not suitable. So when the people themselves started taking over government, taking over from the king, and asserting democracy, they also created for themselves what you call professional judges. And that is a distinction we must always keep at the back of our mind. Professional judges were created for the very reason that they did not want to have wise, quote and unquote, kingly judges. People wanted to have certainty, to know what judgments will be given on any particular occasion. So that is why, as I've then pointed out, when these professional judges came around, there were then things that were needed to put them in check, to remind them that they were not kingly judges, that they were independent professionals. So, in the first place, those integrity questions, before you are appointed, they look into your integrity, your honesty, your reputation in the society. Because no matter what, if you put safeguards and you bring in somebody who is perverse, he will always find a way of undermining the laws. So it was important to have that. And you see it written down in the qualifications of most judges. Then, most jurisdictions for judges. Then, for the part on competency, that's why you now have, in many places, as development of the law came into place, to guard against breach of rule of law, it was required that there will be people trained, people who have already been trained in the basic rules. And that is why there was a requirement for them to be lawyers. And these lawyers needed to be trained also. And that is the development of the academics, the law teachers.
Now, during the time when cases were going on, even in Nigeria, there was not a professional body of lawyers, whether in England or in Nigeria, at the start. No. In fact, there's a case I'm doing, which is still on now, a case that started in 1931, and is still on in our courts now. Now, if you look at that case, you will find that the people that we have now evolved, that have now evolved into what we are as professionals, were letter writers, many times court clerks, people who were in the habit of attending courts and understanding the procedures. So gradually, they now started taking cases, telling people the likelihood of getting judgment, that this Mwadisi, he doesn't like people who come in and are looking dirty. So at least wash up before you come. Okay? So they were the people, but they will not appear in court. So if you look at the record of proceedings, they were not there. Then later on, our rules developed, and in our various statutes, there was provision for people to act as advocates. But their fees were strictly regulated by the courts in which they were going to appear in. So what we're saying is that that is how also the professional lawyer developed. We have all these developments owing to what? The requirement for consistency, to avoid caprice, to avoid inconsistency, to ensure that there is some sort of certainty, predictability about our outcomes in judicial matters. So if we understand this background, we will now understand the issue of per INCURIAM REAGITATA, Nigeria's superiority rule for regulating divergent Supreme Court's decisions. We have now established that it is a good thing and it is an ideal. It is a model for us to have consistency. So it's no longer an argument. The whole basis of our profession is from it. So what we are now asking is, if you look at the rule that gives room for consistency, coherence, you will find that it is the rule we call stare decisis. Stare decisis simply means taking care to follow prior decisions. Notice, I have not yet said prior decisions of a higher court. It started off as prior decision. So it's also a sort of control that instead of allowing a judge to have the capacity to make a judgment and then rely only on his previous judgments, to make a judgment and make any other judgment in future which he likes, it is a control, even if it's a small one, it's a control to tell him, I'm not telling you to look at any other judge or any senior judge. I'm telling you, your own judgment, just rely on what you have said before. So that's how it started. But then it expanded because ordinarily, again, and this is something, because of many years, we have now forgotten it. Ordinarily, we did not really have in England a court of appeal. What we had were courts that were set up as delegates of the king, and they were complete in themselves. Later on, with the Supreme Court of Judicature in 1873 to 1875, it was found that this was becoming burdensome. This judge will give this judgment, this one will give another one. The court of equity tried to settle this matter, but the effect they had was limited. So it was considered in the course of the judgments that there will be in the Supreme Court of Judicature, which meant the High Court, that there will be a division of the High Court called the Appellate Division of the Supreme Court of Judicature. That's how the Court of Appeal started in England. It was much later that the acts were amended and the Court of Appeal was created. But ordinarily, if you read the old judgments, you will see where a judge, you see Okeke for J, sitting on a matter that is an appeal with somebody who is a Lord Justice. You will see, because all of them, senior persons who have judicial experience, were selected by the Lord Chief Justice, not the Lord Chancellor, the Lord Chief Justice, to hear cases depending on the size and seriousness of those cases. So what we are saying again is that it is important to know the conceptual basis, the historical background, for you to understand what the problem we are facing now is all about. In Nigeria itself, a similar thing happened. You find that the Native Codes Ordinance, the earlier ones, 1948, earlier than that, the ones that were made under the 1923 laws of Nigeria, as an adjunct, as a part of the courts created by the Supreme Court Ordinance 1863 of the settlement of Lagos, which was only for the colony. And the Supreme Court at that time was just in the nature of a high court. Our Supreme Court only became the final appellate court in 1963. It has always been originally the High Court of Lagos State, if you were using today's terminology. And in that Supreme Court ordinance, including the one of 1914, you will see that the provision in section 7 is that when more than one of these judges sat to hear an appeal, that they constituted the appellate division of the Supreme Court. So even in Nigeria, we had an appellate court for the High Court, but that appellate court was itself the High Court, because the colonial people, secretaries of states, who were writing these laws for us, were quite attuned with what was happening even as recently as 13 years earlier in the Supreme Court of Judicature Act in their own country. So they were trying to apply it into our own country. The customary courts were all in all at the time, and the only thing was that during the colonial time, there was provision, because the white people would not want to be controlled by judgments of these natives. But also they did not want to make provisions that would alienate the natives. And in any case, they said it as if they were doing a favor to us. It was more a practical thing. They didn't have the manpower. They couldn't have enough judges to go around. So what you had at that time were provincial courts in all of the provinces of Nigeria. I remember at that time, in the earlier stages, Nigeria was not unified, as it were, in terms of the judiciary. So while the Supreme Court was only for the colony of Lagos and aspects of the Southern Protectorate that had been eaten in by the colony of Lagos, the territory of Lagos, the others, the Southern Protectorate and the Northern Protectorate, had their own system of courts. So what they did in the statute was to create for us provincial courts headed by the residents. They were also called the residence courts. So these provincial courts had jurisdiction also where the people we now call them Mwadisi will also be there under them as district courts. The native courts were for the natives themselves, and it was gradually later on that they now started assimilating, bringing the ideas of new law to these people. And the people for us, the white people who were doing our judging, were usually people who were in captain, you see Captain Lane Knott or whatever. These are the DCs, the district officers for these divisions. They were just, people, most of them did not have any legal experience, but at least they were literate, So when you have that understanding, you will now come down to where we're going to. And that is, what this issue of stare decisis precedent, when we have now created these appellate courts, it was necessary that there should be a way of ensuring that decisions that were made were controlled by decisions made by, as it were, more experienced judges in the hierarchy of courts. So, stare decisis was now more established. And the principle in it is quite simple. It is that past decisions should control current ones or future ones. Past decisions should control current ones. And these past decisions that control current ones should be the past decision of the court itself, because that was the original one. And past decisions of courts senior or higher in hierarchy than the court itself that is now trying to find what decision to rely on. Now, that rule is simple enough and quite easy. I mean, for decisions made by a higher court, there's really no difficulty in that. You know, of course, that whether it was done in future or in the past, you know you have to follow it. That's the standard practice. But the problem is, what of decisions made by courts of coordinate jurisdiction? If I am a judge, I have a matter before me now, and there are two past decisions made, none of them by a court higher than me. These decisions were made by courts of my own cadre. Which of these should I follow? Am I still bound by the rule as it stood? That is, just simply follow past rules. Now, if there's a conflict in these past rules, which of them should I follow? That is a problem. My Lord identified it as at the Supreme Court level, but it also applies at the positions lower than the Supreme Court. The traditional view was that for courts of original jurisdiction, where trial was summary and we needed speed, there was no question. Just go ahead, give your judgment. It is assumed that your colleague, if he or she gave his own judgment that is contrary to it, it might have been done speedily. And if you think that your own is better, go ahead and follow your own. So you were not so much bound by decisions of your coordinate court, provided it is in exercise of original jurisdiction. However, and this is a deduction made from the principle established by Young and Bristol Aeroplane Company in 1944 by the Court of Appeal in England, Lord Green. The position, Lord Green MR, Master of the Rules. The position there is that if it is a court that was exercising appellate jurisdiction that gave that judgment, and you are called upon to decide which of the two you should take, the court says, the rule says that you are bound by all previous judgments, decisions, even by courts of coordinate jurisdiction. If it's appellate, the principle behind it being that, look, even if it were to be a magistrate court that was sitting on appeal in those days when we had appellate jurisdiction of magistrate courts over customary courts, if the magistrate had ruled to give guidance to those customary courts, it is expected that another magistrate, if a similar case comes before it, should not give a different decision, even if he feels that it's a bad one that was given before. For consistency and coherence, and not to confuse the lower courts that have been guided by that appellate decision, he should follow that decision and wait for the high courts, which had appellate jurisdiction over them, to correct them or affirm that what they have said is the correct one. But to avoid confusion, you must follow. So, if you notice this, what we are trying gradually establishing here is that the principle behind stare decisis is not so much the wisdom of the relative wisdom of the previous judgments you're looking at. The sole factor is consistency, coherence of the entire system. So when it is for res judicata, for example, when you are dealing with just the parties before you, when you have made a decision, it is final. It is so final that the Supreme Court has held in Ngwo and Monye in March of 1970, in the case of Ngwo and Monye, that's 1970 All Nigeria Law Reports, I think starting from page 91 to about 101 or 102. You see, the Coca JSC, you can't beat Coca JSC. And this was, with the greatest respect, the dominant mind in the Supreme Court of the early 70s. He presented the most in terms of ideological vigor and content in the Supreme Court of 1970s, early 1970s. And he held, in a case where maybe just a little of the facts for you to see where I'm driving at regarding res judicata. In that case, he held that in a case where the decision was by a high court, Pressed J of the Warri High Court, settling finally the dispute between the parties. Later on, this case, the family, about 20 years after 1931, when that judgment, in that judgment, the court set aside the district court's order of Captain Pike North Court. About 20 years or 30 years, 20 years after, about 1956, the family forgot that they had gone and had that decision in the High Court, and that the decision set aside the decision of the District Court of Pike North, Captain Pike North, and held that the parties should go and rehear the case. They later settled the matter in 1936 privately by settlement of 1936. They then entirely forgot this because the representatives that were representing the families maybe had died off. So more than 20 years later, they started a suit again. And the suit started at the High Court, Benin, this time. And then there was no court of appeal at that time. So the next rung of the appellate ladder was the Supreme Court. They went there. Both parties had forgotten that the decision of Pike North of 1931 had been set aside, of earlier than 1931, had been set aside in 1931 by the High Court. They then argued their cases, and the Supreme Court, believing that Pike North's decision, which was tendered and exhibited before it, was still valid, gave a ruling, made his decision, giving the land, declaring the land in favor of the other party, the plaintiff in this new case, while it was the defendant in the old case that won. So, what happened? As is the nature of this source of disputes, another dispute later arose, and they found a judgment, and they found a settlement decision of 1936, and they said, come on, this is not right. Pike North's decision has been overruled, and my lords of the Supreme Court have now given a judgment that depended entirely on that decision. So they came to the High Court in Benin, presided over by Prof. J, and then put all their cards on the table, showed all the decisions and all the things that constituted res judicata between these parties and their previes. And the remarkable thing, and that is something that we should pay tribute to the colonial judicial system at that time, that it did not thrive in intimidating judges of courts lower than the Supreme Court. Prof. J was able, after going through the law, making an assessment of what was involved, he came to the decision that that decision of the Supreme Court, of course with the best diplomatic language and politeness, was reached per incuriam. That the doctrine of per incuriam is that when a decision is reached in circumstances suggesting that it was reached contrary to a previous one that would otherwise have been binding on it, that any judgment that is contrary will be held to be unenforceable and per incuriam. This was astounding. But the more outstanding thing is not just the courage of Prof. J to have given that kind of judgment. What was more outstanding was that when he came up before Coker, R.A.C.E, and his brethren justices of the Supreme Court in 1970, they reviewed the entire thing, and Coker, R.A.C.E, reading the judgment of the court in those days, you don't need to write separate judgments. After conference, when the judges agree on what the decision will be, they can assign one of the judges to write and read it. So, reading the judgment of the Supreme Court, Coker, R.A.C.E found that, look, the doctrine of per incuriam applies if this is truly the case. And from the evidence which was not rebutted, this was truly the case. The time when they gave their judgment as R.A.C.E in 1956 or thereabouts, they did not know that this judgment between the parties had already been set aside. So they relied on it as res judicata. If it had been brought to their attention, the law is that res judicata settles matters. If you don't go on appeal, even if it is a customary court that gave a judgment, if you do not go on appeal on it, you are bound by it, and the Supreme Court will enforce it. So they did not know, and they gave their judgment based on this lack of knowledge, the ignorance of this issue that would have guided them. And the Supreme Court agreed with Press J and held that their judgment as Supreme Court was reached per incuriam. And therefore, that judgment could not stand. And that the judgment of Press J was the appropriate one to use. So, you see the issue here. And the point we will eventually land at is that it is because we have forgotten, gradually, we have forgotten these guardrails, these conceptual and historical guardrails that has prompted the kind of chaos of inconsistencies that we now have in our judicial system. I've had the opportunity to deal with this, so I will not dwell on it again. In a volume edited by my learned friend, Professor George Nnona, on behalf of the Faculty of Law, University of Nigeria, which, unfortunately, because of internal problems, was not distributed. I had dealt with this issue, pointing out a series of inconsistencies in our courts. In 2013, when this essay was published as chapter 3 of that volume of lectures marking the 50th anniversary of the University of Nigeria Law Faculty, which incidentally is the first law faculty in Nigeria. Okay, so that's judicial flip-flops and theory deficits in the Supreme Court. Have Nigerian law faculties flunked their final exams? In it, I traced a lot of these inconsistencies. I do not need to rehash them here. So what I would rather do is get into the problems that we are now currently facing. What is the greatest problem? It is true that many courts do not realize the distinction I have drawn between the judgment between parties, which in Latin we have encompassed in the doctrine of res judicata, as distinguished from the sociologically more important one that governs the larger society and ensuring that our system of justice stands secure in coherence and certainty and predictability. This one is the one called stare decisis, or precedent. So, where do we have this problem? It's easy enough when the courts have forgotten that courts of coordinate jurisdiction, especially at the Court of Appeal level, are not permitted to say, as one of the examples my Lord pointed out here, which I'm grateful for, to say that they can choose which of their prior decisions they should take. No. This thing has been settled. It's like 86 years now. Been long settled. In England, the Court of Appeal cannot pick and choose. It is bound by the Court of Appeal is bound by the Court of Appeal. There's no going around it. You are bound by the Court of Appeal. The only exceptions are stated there. When Koka JSC of the Supreme Court was adopting this decision of the Court of Appeal in England as a decision of the Supreme Court in Ngo Amonye, he pointed out, agreeing with Lord Green MR, the 4 exceptions to this. The first, which is not really an exception as it were, because it stands to reason. The first is when there is no prior decision of a superior court on the matter. Of course, the judge is entitled to proceed with his own. The other one is when there's a prior decision of the House of Lords, in our case, the Supreme Court. Of course, the judge must follow. There's no question about it. He must, even if that judgment is bad, if it's erroneous in law. Remember, error in law is not the same thing as being per incuriam. A judgment might be fantastically well written and brilliant, but still be per incuriam, because it did not follow a past binding decision that was not brought to his attention. And a judgment that is incompetent, that has no basis to commend it, may still not be per incuriam. Because if saw the previous judgments, it purported to follow it, then applied a travesty of what you would say is application of law. That is merely an error. It does not give ground for the junior court to say that it will not follow it. You must follow that bad judgment. All you can do is to point out your concerns about it and let the parties go to the higher court to reverse it. So, the third the court pointed out was where there are prior decisions of the Court of Appeal itself. But these decisions were contrary to a later decision or any other decision of the Supreme Court. So this one is a judgment that was given by the Court of Appeal on Monday. So the Supreme Court had not said anything about it. Then on Tuesday, the Supreme Court gave a decision, not even knowing about the Court of Appeal, so it didn't expressly overrule it. It just gave a decision that is contrary to that Court of Appeal decision of Monday. The Supreme Court gave its own contrary decision on Tuesday. Then a case comes up again on Wednesday before another Court of Appeal panel or the same Court of Appeal panel. And it is required to choose a prior decision that it will take. The court is saying in Lord Green's exceptions that this is the only time when the Court of Appeal can depart from its own previous decision and choose the one made by the higher court, because it is contrary to it by implication, even though it was not expressly so stated. Then the fourth one is what they call, it's described as a special case scenario. And this special case scenario is where it says that it is when a decision was given that is inconsistent with a prior decision or a prior statute, because per incuriam applies to statutes and decisions. So a prior judgment or statute that would otherwise have been binding on the court, but which was not brought to his attention either by the counsel appearing before the court or the court itself in his own private research. So those are the four exceptions. But apart from that, the Court of Appeal is bound to follow judgments of the Supreme Court or the court higher than it, as well as its own judgments of courts of coordinate jurisdiction. Now, this is where it gets a bit more interesting and complex. And again, I have to pay gratitude to my Lord the Chairman for so easily simplifying it for me, because he so brought it out in vivid perspective. Now, look, when we are talking about per incuriam, it's all about past decisions. What of a situation? We have all agreed that a judgment of a superior court will bind us at the lower court. Now, if in Nigeria, where at the top of the hierarchy of courts is the Supreme Court, what if the Supreme Court has given a previous contrary judgment to a decision that was given much earlier by the same Supreme Court, not any other court lower than it? So, using our same example again, on Monday, the Supreme Court said that black is white. On Tuesday, the Supreme Court, a different panel perhaps, without adverting its mind to the decision of Monday, on that Tuesday, it says that black is black, which is contrary. Then, on Wednesday, the Court of Appeal is faced with a case that depends on a determination of whether white is black or black is black. Which of the prior decisions that we have agreed the Supreme Court binds them? Which of these binding Supreme Court authorities, decisions, should it take? This is what I have described as superiority rules. It's my own attempt to put it into a cubicle. You can use your own words. So what my lecture today will be driving at is to try to find out, and this is where we're now focusing on the lecture, what is Nigeria's superiority rule for regulating divergent Supreme Court cases? Is there such a rule? If there's such a rule, what is that rule? That is the focus of this lecture, and that's the fourth claim of this lecture. The fifth claim will then be on the conclusions. Now, this problem is, gives room to something like an antinomy, a logical antinomy. Whichever way you go, you lose. Because ordinarily, our Constitution in its clear letters says that the final court we'll have is the Supreme Court. It didn't say the later or earlier Supreme, it said Supreme Court. And then, there's no Supreme Court that is higher in status when we are talking about stare decisis or precedent or even REAGITATA than another Supreme Court. So, the rule is that a subordinate court should obey the Supreme Court. And it's now faced with two decisions of the Supreme Court. Under the normal rule of stare decisis, that subordinate court is bound to follow the decision of Monday and also the decision of Tuesday. But this is impossible because it's a contradiction in terms. It's an internal inconsistency. It's an internal contradiction. That's why it's an antinomy. But the courts have not been left without some guidance as to resolve this. Our problem, however, and this is regarding perhaps the conclusions we are going to make, is that we have had the problem of ego setting into our arrangement of courts. We have forgotten that superior courts of record in the old England were deemed to be of virtually the same status. And that there's nothing, if we think about it clearly, that necessarily, inherently, determines the preferment of one judge of the High Court to another judge of the High Court when it comes in terms of intellectual integrity or other abilities for preferment or elevation to the Court of Appeal. And similarly, when it comes to the Court of Appeal, from that pool, there's nothing, if you think about it, that necessarily determines the selection of one justice of the Court of Appeal over the other for elevation to the Supreme Court. So, if that is the case, why do we overburden the issues that are simply issues of administration into matters that deal with ego? And we've so regimented our judiciary that it is shocking the kind of seeming fear that you find amongst people who should recognize others as first amongst equals. It's unfortunate, but I see that as one of the reasons that we're facing the difficulties we're facing now. Because it has an effect on the rules, that the guidelines that have been set to ensure that the kind of inconsistencies we're facing now would not arise. Like the issue of what defines an obiter dictum. An obiter dictum does not necessarily mean that that judgment is something that is below intelligence. It doesn't mean it's less than intelligent. In fact, an obiter dictum may be better than the ratio decidendi in a case. But the rule is a procedural rule for larger society, not necessarily for the immediate justice of the parties. So, what has happened has been that ego has set in, and instead of allowing the rules that have been settled for hundreds of years, that when a court gives a decision and the issues that are set by the parties before the court have been dealt with, and the court goes in to add something else, no matter how intelligent that thing is, it is an obiter dictum. But the thing is that we've added negativity to that term. So people are afraid, subordinate courts are now afraid of declaring that a decision is obiter dicta when it is from a court higher than it. But this has no basis in law. And I'll show you by a circus of a comedy of errors how we came to this sorry pass. It's just in recent times. It has not always been this way. Our courts have known the reason for these guardrails that protect us against inconsistency, and they followed it. But in recent times, this has gone awry. So, what is the position? What gives grounds for the courts to say that it is one or the other of the Supreme Court rules or Supreme Court decisions that should be taken as the one that binds rather than the other? First of all, reading through the cases, I would make the respectful submission that what I can deduce for the choice that eventually became the superiority rule that governs this matter is this simple thing. The options are principally two. You either follow the past decision, or you follow you follow either the former decision. Remember, all of them are past decisions. So we are now looking at the one that is more past than the other. So, yes. So when we are talking about the former from the latter. Which of the two will guide future courts? And the principle is, let's think about it logically. If you say, as my Lord Ogwagu JSC said in Osakwe and Federal College of Education Technical in March of 2010 with my Lord's brethren judges, that it is the last of the two conflicting Supreme Court decisions that you must follow. The consequence in logical terms is that there's no rule. There's no rule for the Supreme Court anymore. It means that the Supreme Court is not bound by the dictates of the rule of law. It means that it has nothing it needs to refer to. Because if he makes a wrong decision, if he fails to do the due diligence required in reading, researching, going through his library to know what has been decided by himself before, and the reward he gets is that that decision he makes will overturn the decision that was made previous to it by the same Supreme Court. What you're saying is you're granting carte blanche to the Supreme Court to be, as it were, a capricious court. And remember the background we laid, the conceptual and historical background about having professional judges, having professional lawyers, having professional teachers of law, that all these are geared to protecting society and ensuring that there's consistency and there will not be caprice. So if this option suggested, well, not suggested, determined by the court in 2010, led by Ogwagu JSC, my Lord Ogwagu JSC, then we are back to square one. We are back to the judgments of the kingly judges, not bound by any rules. And the subordinate courts, they don't have anything to be sure of anymore because there's nothing they can say. Even if this matter goes to the Supreme Court, there's a more than likely chance that the Supreme Court will still return this decision. Because the Supreme Court is no longer bound by its own decision. So it means that even the subordinate courts are in a quandary because when they are making their decisions, they'll be worried about perhaps even this previous one that the Supreme Court said, the Supreme Court can change it tomorrow. Then the other option, which in my respectful submission is the superiority rule regulating divergent Supreme Court decisions in Nigeria and elsewhere in most of Commonwealth and common law countries, is that it is the decision of the Supreme Court that was reached earliest in time without, and this is very important, without being expressly overruled. That's the important thing, because the question always is, no, if we follow prior decisions, shouldn't we say that, are we saying that the Supreme Court can't overrule itself? Actually, at a time, the Supreme Court could not overrule itself. It was only in 1970-71, in Johnson and Lawanson, that they had this power. And they took it after 1966, when the Privy Council gave itself that power to overrule itself, because also the Privy Council felt it was bound by its own previous decisions. And the House of Lords, there was no question, they held themselves bound by their previous decisions. So the common law which we borrowed from had a standing device for
superiority rules, which is that the top court, because of this hierarchy of courts, that when he gets to the top court and he has no other person to obey, he must obey himself. And that is just like my Lord the King, the Almighty, when he says that when I looked and didn't find anybody from whom I could swear an oath, because there's no other person greater than I swore by my own name. So it's the same thing. The Supreme Court, by this principle that was evolved, decided that because there's no other person he can swear by, it will swear by itself. The House of Lords set that precedent. The Privy Council gradually broke it because Privy Council was an appellate court over courts outside England. It did not have jurisdiction over England. It was the House of Lords that had jurisdiction there. So gradually, because of the possibilities of very, very bad laws, judgments that might cause injustice, they gave to themselves the power to overrule their prior decisions. And therefore, yes, our Supreme Court, since Johnson and Lawrenson, has accepted that jurisdiction and is no longer something that is open to argument. The Supreme Court can indeed overrule itself, but it does not make a habit of doing it. The decisions, through a long list, Odi and Osafile, a long list of the authorities, the Supreme Court has said, before we even do that, because of the history we have of not accepting that power before, now we have given ourselves that power. Before we will exercise that power, there are safeguards. We will impanel a court, which people call the full court. But, I think that is a misnomer, because full court in its original essence meant the appellate court. Whenever the Supreme Court, as a high court, sat in more than one judge on appeal over his own decision, it was called the full court under the Supreme Court Ordinance of 1863 as amended up to 1914, and in future. So that was the full court. But I prefer to call it the full panel. He says the full panel is normally the Supreme Court when it sits with a minimum of 5 justices. But when it wants to overrule itself under its own Supreme Court rules, it's there. There's a requirement that if you wish to make an argument at the Supreme Court that it should overrule any of its decisions, in your brief, whether the appellant's brief, respondent's brief, or reply brief, or whatever brief, you must put it there and highlight the paragraph that you are calling upon the Supreme Court to overrule this decision or that decision of its own self. Now, what I'm saying is that it tells you the kind of guardrails the Supreme Court is putting, so that you don't just flip over a decision overnight. So, having those guardrails in place, my respectful submission is that the better view is the view that has been taken in a long line of cases, especially in the Adekoke Motors case of May 1989, Odi and Osafile, especially 1990, January. There are several of them. So those decisions say that the Supreme Court feels bound by its own prior decisions, and it only will depart from any such decisions when it has been given sufficient reason to so depart. And when it expressly departs from a decision, then and only then can it rely on a future decision that is contrary to that one. So what the law is this, that for the two options of whether it is
the past decision, the former decision, or the latter one amongst the conflicting judgments of the Supreme Court, that it is the former one, provided it has not expressly been overruled by the Supreme Court. Now, how did we even come to the point where the suggestion has arisen that it is the last one of the conflicting decisions that the subordinate courts from the Court of Appeal down to the customary court must follow? It's of recent origin, actually. And it is that 2010 judgment of the Supreme Court that started it at the Supreme Court. My Lord Ogbuagu JSC, but this is very interesting. I want you to pay, with the greatest respect, attention to how this arose. My Lord Ogbuagu JSC, in 2010, in that case of Osakwe and Federal College of Education Technical of 2010 March, came to the decision, unjustly, in my respectful view, trashing the better view raised by my Lord Ogunwumiju, JCA as she then was, now JSC, of the Court of Appeal. The attack was somewhat unfriendly, and it didn't seem to have arisen from just complaining about a judge choosing one of the prior decision of the Supreme Court. But let me not go into that anymore. But the reprimand was a bit severe. I suggest it was uncalled for. And as it turns out, wrong. In that decision, my Lord relied on the decision of Ogundare JCA, as it then was, in Spanner also versus Bendel newspapers. Now, this is the interesting part. Ogundare JCA, in Spanner also, did indeed say that it's the last decision that would bind the Court of Appeal. But he did not give any reasoned arguments to back up his submission. He just said that at the Court of Appeal. But then, now remember, my Lord Ogbuagu JSC was relying on this Court of Appeal decision in 2010. But then, note, 4 years after 1990, when Spanner also was decided by Ogundare JCA, my Lord Ogundare JCA had been promoted to the Court of Supreme Court. And in the case of Adeshoko versus Adetunji, she has left. I wanted to know the proper pronunciation. Spelled as Adesokan. Adesokan. But I understand that Yoruba pronunciation, S is sh. Yeah, so Adeshoko. Am I correct? Yeah. Adeshoko and Adetunji. Who read the leading judgment in Adeshoko and Adetunji in 1994? The same June. He gave his decision in Spanner also in June 1990. And almost exactly 4 years to the date, in June, 10th June, 1994, Ogundare JSC, M.E. Ogundare JSC, gave the leading judgment, led a full panel of 7 Supreme Court justices in Adeshoko and Adetunji. And what did he say? He said that the Supreme Court is bound by its previous decisions. And therefore, if a later one did not take account of the oldest one, it means that that later one has breached this rule
that the Supreme Court should be bound by its previous decisions. And therefore, that it was a decision reached per incuriam. You didn't put that on the words. It was per incuriam. In fact, the 6 justices wholeheartedly agreed with him in that decision. But the most interesting was Ono JSC. He went all the way and said that it was not just the Supreme Court that was entitled to make that determination, that even the subordinate courts are bound by it. Ajo JSC, although asserting a concurrence, was, in my respectful submission, a disguised dissent. On the conclusion of the judgment, he agreed with the majority decision. But on the reasoning, my Lord Ajo JSC tried to wiggle in this problem that we are still facing. And he suggested that it is not for junior courts, courts subordinate to the Supreme Court, to come to a decision whether the courts had made a decision that is per incuriam or not. That they should do it this way. That just as Ogundare JSC has now looked at the past decisions and found that this other one was not to be followed, that when it comes to the Court of Appeal and such a case comes, the court should surrender its duties of deciding on the matter and wait till the Supreme Court makes a determination. But then he cleverly did not tell the Court of Appeal what he should do. Should he then follow the latest of the decisions? Because that's the elephant in the room. Should he follow the latest of the decisions and abandon the former one? He didn't say that one. He just simply said, how can a subordinate court tell a Supreme Court that it has given a decision that is per incuriam? And that's the problem. You will see here that the problem is a matter of ego. But sometimes it may not also just be a matter of ego. It may be a matter of innocence of the full ramifications of that legal terminology. The problem, as it is that my lords who have paid heed to this attitude of mind that a lower court cannot say that a superior court judgment was reached per incuriam or as an obiter dictum, that what they have done is that they have ascribed a negative connotation to a word that is merely neutral, or a maxim that is merely neutral. Obiter dictum is a neutral terminology. Per incuriam is neutral because it may well be that the lawyers failed in their duty to bring to the attention of the judge, who has so many cases to deal with. If the counsel failed to bring to his attention the previous judgments, then you cannot blame him for giving a judgment that did not advert to that case. So it's not something that we should kill ourselves over and think that it is a negative term and therefore a court lower in hierarchy should not do it. And it is brought out in bigger focus. Sometimes, and that's the second thing under which my conclusion is that we have fallen into this problem. Apart from ego, there seems also to be, how do I put it delicately without being impolite? Some of the justices have been innocent of the full ramifications of the concept behind this phraseology. So it's brought out in boldly. Sometimes it can be done maliciously.
sometimes it can be just done, not ignorantly, but innocently. And it is brought out in bold relief regarding the issue of obiter. Something as simple as obiter dicta. Everybody knows what obiter dicta mean in law. This is something you're taught in second year. My Professor Obu Osita is an expert on legal systems. So this is what he teaches in second year. So any person who has passed through second year of law knows what obiter dicta mean. It does not mean that the judge is not intelligent. It just means, in fact, contrary to it, most of the obiter dicta are usually very intelligent, illuminating things. But it's on a subject that is not addressed by the parties in the issues brought before the court. That's all. But look at what has happened. In the case of Ife Diora and Ume, one of the most brilliant justices that has sat on the Court of Appeal and in the Supreme Court, my Lord Emeka Agujes, stated that yes, we all know the rule as obiter dicta, and that obiter dicta does not bind lower courts or any court at all. But, this is paraphrasing him, but when it concerns the highest court in the land, the House of Lords has decided in England in 1967, in the case of W.B. Anderson, that the obiter dicta of the House of Lords, and therefore the Supreme Court, is binding on all subordinate courts. Now, what has this cost me? Because I have to research this issue, I have the unpleasant task of now going to look for W.B. Anderson, the case of 1967. And was it the House of Lords that gave that decision? No. But my Lord said that it's House of Lords in order to give power to the suggestion he made that is outside what the law is. Was it the decision of the Court of Appeal? Not even the Court of Appeal. The W.B. Anderson decision was made by Ken J. of the High Court of Justice in England, of the King's Bench Division. So, now, after my Lord gave this decision in Ife Diora and Ume, 1988, other judges, and you cannot blame subordinate courts for following it, because this is what the Supreme Court has said. So, people have had the attitude that the obiter dicta of the Supreme Court is binding on all subordinate courts. And when this obiter dicta now come in and give decisions that are made not based on reasoned arguments assisted by counsel, because it was not the issue before the court. When it now comes to a case that counsel have now had the opportunity of researching the matter and advising the court, these people are now constrained. The subordinate courts are constrained because the Supreme Court has told them the House of Lords said that obiter dicta are binding on subordinate courts once it's made by the highest court in the land. And this is a problem we're faced with. This problem has led to several problems. Several problems. And the worry is that litigants, we seem not to be paying attention to the problem it gives to litigants. Because of the multiplicity of decisions that are made, judges now have to wade through lots of cases. Because of wading through lots of cases,
they now have less time to pay attention to the quality of their judgments. And when they do not pay attention to the quality of their judgments, the effect is resounding, and it brings down the quality of justice in the entire judicial system. And the worst part of it is that there's no litigation lawyer here. There's no litigation lawyer here that if you tell on any issue of law, you tell him, bring me at least 2 conflicting Supreme Court decisions on this area of law. There's no litigation lawyer here that if you make that request on, within 2 weeks, will not be able to find you at least 1 Supreme Court decision on virtually any area of law. Is it on tenancy law? Is it on procedure? Is it on jurisdiction? Is it on appeal? Is it on the procedure to get into appeals? Is it on criminal law? Any position of law whatsoever. There is a conflicting judgment of the Supreme Court on each of them. What it means is that it gives more work to us as lawyers. And it means that because we have more work, we are going to necessarily have to charge more to our clients, because that's only fair. If you work more, you charge more. So it means that if we charge so much more, it's impacting adversely on the clients. Many of the clients can't pay. And because they can't pay, they will settle these disputes through private militia. So sometimes we stay home and start wondering, why do we have bandits? Why do we have all sorts of associations? Pubs are not IPOBs, or not APOBs, or all sorts of groups. People are now losing trust in our judicial system. The decisions are they're frustrating. Some of us as lawyers have stopped going to court because we know that sometimes the fees we have to charge will be a bit unconscionable even on the clients. You cannot predict. You cannot even tell your client, this is what you need to do, because there's a reasonable certitude that if you do this, you come off clean. If you go to court, you will win. There's no certitude anymore. How can we proceed further? How can we change this? Is there a way to change this? My respectful submission is that there is a way, and it's a simple one. First, we have to trace it to the evolution of law from kingly justice to dispassionate professionals, whether as teachers led by professors of law, whether as judges led by justices of the Supreme Court, whether as litigation lawyers, courtroom lawyers, led by senior advocates of Nigeria. We seem all to have dropped the ball. We have failed in our leadership duties. The guardrails that have been set by our ancestors in the profession to guard against this very ill that we are seeing now, we have allowed them to be whittled down. Sometimes we give opportunity because generally, I can say this, I've practiced long enough to know that the majority of our judges and lawyers and teachers are of the highest quality. But the difficulty is that when you have given room to breaking down of the guardrails that make our profession what it's supposed to be, you give room to the minority of judges who might be corrupt. Of course, present company accepted, who might be incompetent to rely on this potpourri of judgments, disparate judgments, this chaos of conflicting decisions. So when you come to court, a smart but corrupt judge is able to subvert the justice of the case simply by relying on one or the other of two conflicting decisions. Because any of them, he can say that it was made by the Supreme Court. All we need to do if we want to change things is that we have to go back to the past. We have to clarify the concepts. We have to realize that we are not suggesting something novel. This has been there from when we borrowed it in England. The common law has established this. This is not 10 years, this is not hundreds of years. It's not as if it was left there in England or as exported in America where we borrowed our constitution. But we ourselves, our Supreme Court has re-established this principle time without number. Even in recent times, we really need to get back to these things if we need to bring our system of justice back to what it is required to be. That is consistent, coherent, predictable. Thank you very much.
Wow, keep clapping, that's awesome, awesome. Wow. Just like I did earlier on, and I wanted to say amen, I wanted to say praise the Lord again this time. You know, while Prof was talking, I was thinking of four books that ran to my head, 4 reference books. One of them was the Strong's Exhaustive Concordance. The other was Young's Analytical Concordance. The third one was the Oxford Etymological Dictionary of the English Language. And the fourth one was Black's Law Dictionary. Because the talk was exhaustive, analytical, etymological, and a lot of words were defined. Like a dictionary. Thank you, Prof. Let's put your hands together again for Prof. While he was speaking, we had some distinguished people come in. I just want to welcome them before I hand over to the chairman for the conduct of the discussions. Excuse me. Yes, while the lecture was going on, we had Honorable Justice C.O. Aja, A-J-A-H, P-H-D, come in. Honorable Justice Aja. I'm sorry. I'm sorry. Is that you, sir? Oh, is it on? Oh, okay. There was an Honorable Justice C.A. Ogwabo, Ph.D. And we had Honorable Justice E.N. Anamani, Ph.D., come in. You're welcome, sir. Thank you so much, sir. And we had Honorable Justice C.C. Ani, Ph.D., come in. Oh, you're welcome, ma'am, my lord. And yes, then we have here also Mr. Peter Eze. Mr. Peter Eze, a very senior lawyer. You're welcome, sir. We have Dr. Anayo Ede, Secretary, EHDL. Dr. Anayo Ede. What? Gone. Okay. We also had CNN Wagbara, former chairman Enugu Bar. CNN Wagbara. Is he here? Oh, welcome, sir. Mrs. Carol Etuk, Director of Multi-Door Courthouse in the state. Mrs. Carol Etuk. Oh, you're welcome, ma'am. Associate Professor Friday Eloti. Professor Friday Eloti? Oh, yes, sir. Okay, I think that's it for the moment. Right, now just two announcements first. In your packs, there's a form. Please, 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 please. I beseech you, now let me use biblical language now. I beseech you by the mercies of God to fill out the forms before we leave here, please. We need to have those forms for our records. Very much obliged to you. Fill out the forms. Yes, I will collect them from you. Oh, right. Okay, so it's cool. All right. Right. Come on, now. Yes. Right. Also, we have Professor Ogbu Nwobadi. Professor Ogbu. What's Prof? Professor Ogbu Nwobadi. Yeah. Professor Jeff Anyogu. Professor Jeff Anyogu. Sorry? Oh, okay. Okay, I did it. Okay. What was this? Anene Ojiaja. For who? For Turkey. Okay. Oh, yes. I'm sorry. Also, Mr. Anene Ojinta, former chair Enugu Bar. I'm sorry, I'm not from Enugu, I'm from Lagos, so I need to meet everybody. Sorry about that. Well, also, on the family table. Oh, okay. You want to say something? All right, yes, just a little housekeeping thing, just to clear, and then we go to the discussions. I know we're eager for them to start. We have here mommy, grandmommy, Mrs. Elizabeth Akaraiwe, M.Ed. Harvard, the mother and the grandmother of the day, Ike's mother, retired school principal. Mama is 89 years old. You better clap properly. You want to live that old, you better clap properly. 89 years old and looking fit and beautiful. Come on now. Also, we have Dr. Blossom. Where's she? Blossom Akaraiwe. She's there. Come on, Blossom. Give us a wave. Let's see your face. I can't see your face. Miss Soma Akaraiwe. Soma, you there? Okay. Of course, we've introduced Professor, not associate professor, not assistant professor, but Professor Akaraiwe, we've introduced already. Put your hands together for her, please. Right, okay, sorry, thank you. Now that that's done, oh, sorry, I need to say, there's an announcement I was given. It's not an announcement, really. Okay, now we're going to go on to the discussions. The governor and the Attorney General really wants to be part of this discussion. So that's why we're rushing things along so that we can, because it's supposed to be some remarks after in any case, yes. So we're going to start our discussion in order, give me the, yes, in order in which the names are listed here. And I'm very afraid, and really, really sorry. Please pardon me, have mercy on me. You'll have 5 minutes. I know Mr. Madika won more than that. I knew it. All right, so can we have Anthony? He has been represented by Mr. Madika S.A.N. Yes. You can see. Put your hands together, please. No, sir. I think it's better you sit. It's better you sit. It's better you sit.
It's better I sit.
Yes.
Okay.
Put your hands together, please. Thank you. Well done, sir.
My Lord, the chairman of this occasion, my Lord Honorable Justice J.E. Ekanam, Justice of the Court of Appeal, His Excellency the Governor of Enugu State, ably represented by the Attorney General, my Lords, Judges of the High Court of Enugu, both sitting around, members of the panelists, ladies and gentlemen. Now, I think the guest speaker has done justice to this topic. And it's important that we are having, really agitating our minds as it concerns this issue of conflicting judgments at the Supreme Court. Because in recent times, it appears to be a common happening, so that we are gradually taking it as, the norm. But it's important that we are using this occasion of this lecture, to remind ourselves of the inherent dangers in having conflicting decisions of the Supreme Court, the highest court of the land, not just to judges at the lower courts, but also impact on litigation lawyers and even law lecturers. I was asking a professor of law the other day, and we were discussing this same issue of conflicting decisions of the Supreme Court. And I was asking him what they teach their lawyers now, what they teach their students now in view of these conflicting decisions. So it's important that we're having this opportunity to re-examine this very important issue. Now, the guest lecturer, I must say, has done marvelous work of discussing this topic. Now, I picked one thing from what he said. He said this is a recent happening. That it has not always been the case that we're having conflicting decisions of the Supreme Court. Because the emphasis on this is on the Supreme Court, is the highest court of the land. Of course, once they get it right at that level, of course it follows that all lower courts will be bound by the decisions of the Supreme Court, and the judiciary will be better for it, the legal system will be better for it, and we get it right. So that's why it's important that we look at what is happening at the Supreme Court. Now, I want to say that what is happening at the Supreme Court, leading to conflicting decisions of the Supreme Court, is not divorced from what is happening in our larger society. It is the indiscipline, the corruption in the larger society, and that's what has led to the conflicting decisions at the Supreme Court. Now we look at other reasons for these conflicting decisions. And I'm looking at the procedure for appointment of judges to the appellate court, or to the bench. More so the appellate court, the high court, the appellate court and the Supreme Court. Recall that the former NBA president, R.A.C.E, was privileged to sit in a panel of the NJC interrogating or interviewing judges to be elevated to the Supreme Court. And he said that when he raised objection, because apparently some of the justices to be elevated were not in tune with the rules of practice and procedure. And he was told, don't worry, that they will learn on the job. That is when you appoint people who ought not to have been appointed in the first place, who don't even understand some of these principles we are talking about here. And that's why we have conflicting decisions, because they don't know. Even the capacity to research, they may not have that capacity, they may not have the opportunity, they may not have that experience, and the maturity to sit at the highest court of the land to decide some of these matters. And that's why we are having some of these conflicting decisions. And I'm not just talking about appointment to the Supreme Court, even appointment to the high court bench. We should look for the best, people who are competent, people who are knowledgeable enough to be appointed, because these are persons that will get elevated ultimately to the Supreme Court. So we have to go for the best. And these are some of these contributing to these conflicting decisions we are having at the appellate courts. It's also important to make the composition of the Supreme Court very robust. And my thesis is that people from the academia should be appointed to the Supreme Court bench. They'll bring their own experience, they'll bring their own perspective. And of course, that research ability to bear at the Supreme Court bench. So it's important for us to have a mixture of judges who have had a long career on the bench, and also people appointing people from the bar and also from the academia into the highest court of the land. It will enrich that court, and it will eliminate to a large extent some of these conflicting decisions. My also other thesis is that this issue, of course, the guest lecturer has made the point that the decision to be followed is the earliest decision of the Supreme Court, unless it is expressly overruled. Now, you find that sometimes even the judges of the lower court may want to follow that earliest decision. But of course, in the process of appointing them to the higher bench, some of these justices of the Supreme Court, they may have impact. They may sit, as members of the NJC, and they'll be looking at, this judge that had the audacity to say that my judgment was reached by INCURIAM. Of course, the judges will be apprehensive. They will look at what will happen to them when they get at that stage of being elevated. So, my suggestion is that this issue should be codified. We have it in the law, in the Constitution, and say that decisions of the earliest decision of the Supreme Court is binding on the Supreme Court and all lower courts, except if it is expressly overruled. In which case, the judges of the lower court will have the confidence in relying on that earliest decision, knowing full well that they are following the Constitution. This is the provision of the Constitution, and nothing will happen to them if they follow that Constitution.
Thank you,
that
sir.
Provision of Constitution. Just let me just run off.
Yes.
Now, it's also important, sir, that we, when we've codified this issue as to the superiority of the decisions of the Supreme Court to be followed, we can also have panels. When it is clear, when it is obvious that a judgment of the Supreme Court was reached by INCURIAM, there should be an independent body. The case should be referred to an independent body, not just constituted by the justices of the Supreme Court, but an independent body that will examine why that decision was reached by INCURIAM, despite that express provision of the Constitution, which says you have to follow the earliest decision, and sanctions should be meted out. And also on behalf of lawyers, because some of us lawyers take cases to these appellate courts, knowing full well that this is not the position of the law. We go before these courts to agitate these matters, when we know full well that this is not the position. And we lead these courts into making these decisions that are reached by INCURIAM into these conflicting decisions. Lawyers should also be sanctioned. Thank you.
Thank you, sir. You spent more than 10 minutes, and well, thank you anyway. You didn't make the point. More than, actually. Sorry, Mr. Fides Madu. Oh, please, I'm so sorry. Put your hands together again for that submission. It was excellent. It was more than time, but it was good.
The chairman of the occasion, Honorable Judge, my Lord Honorable Justice Ekenam, because Judge of course the Court of Appeal, and the representative of the Governor, the Attorney General. Well, we overstretched this issue of conflict of decisions at the Supreme Court. My Lord made a clear foundation on this, and the lecturer also blended everything together. The question is, when is being confronted by the judges at the lower court, what would they do? That's the major question. Now, the lecturer made mention of the superiority rules, the earliest the earliest in time of the authority. Now, in that Adegoke and Adegoke methods,
Sir,
the judges...
Sorry.
Yeah.
I'm sorry. It's a public service announcement. There's a vehicle blocking the entrance. AGL 400CH, a Ford Jeep, a Lagos number. AGL 400CH, Ford Jeep is blocking the entrance. You'd like to get towed. Sorry, sir.
Yes, sorry. Now, in the case of Adegoke methods and Adesanya, my laws made it clear that when you are confronted with this kind of issue, caution should not be thrown to the wind. You have to look at the facts and the law before you. You see,
you might decide to take up the earliest one. The question, would that earliest one be on all fours with the case before you? If you look at the case before you, the facts and the law, I think that is the only way you will determine the superiority of the ones you are going to take in the conflicting judgments. Because counsel will be on the other side with that authority, the other one will be on the other authority with the same thing. Then the question is, which one will I follow to get the justice of the case before me? The only fact, the only issue that will guide you is the facts of your case at that time, the law applicable. Then you will determine and look at the conflicting judgments and look at the one that is better and the one that solves the justice of the case. If you can determine that, I think it will come to an end. My learned brother made mention of setting a panel or codifying the rules. It will not help the problem. They have gotten a lot of conflicting judgments. Where will you start? So the question is, how are we going to solve the problem when it confronts us, especially the trial judges? You look at the facts before you, you look at the cases before you. If you look at the issue of the case of this case, the Benjamin and Kalio on issue of administrator of unregistered document, you see, when judgment was delivered, after 1 year, my Lord Justice Wednesday came up with another case in Abudulayi. He made it clear that it doesn't matter. But you look at the facts of that case and the one he determined, they're very different. You now said, if you plead that document as a receipt or equitable instrument, it can be tendered. But the point is that we don't look at the facts of the case and the laws before us before we determine or choose the conflicting judgment, both of them the one you are going to take. So I think the only thing that will guide us, we the practicing lawyers and the judges, is the facts and the law of the case before us. That will determine the best way and the conflicting case we are going to follow. But if you follow the earliest one, if it's not enough force with the facts before you, what will you do? So thank you very much.
Thank you, sir. Thank you. Put your hands together for Ms. Mbadua. Now we call on Mrs. Ifeoma Adara.
My Lord,
ma'am, you got 5 minutes.
Okay, thank you. My Lord, the chairman of the occasion, Justice of Court of Appeal, Justice Ekanem, and the Honorable AG, permit me to stand on existing protocols. During my loan off, he made a statement that caught my attention. He said that the rate at which conflicting decisions are churned out from the apex court is rising. I would say is at an alarming rate. And the question is, what is the impact on the general society? What is the impact of this conflicting statements on the victims of judgments reached per INCURIAM by the... My Lord, I want to refer us to the quotation of the landmark case of Adegoke. What Justice Chukwudi Akunoputa said. He said that the wise decision, he said it is true that this court can do inestimable good is wise decision. Similarly, the court can do incalculable harm through its mistakes. Now the question is, why the thoughtlessness in the apex court, especially in decisions reached per INCURIAM? Why don't we look at the root causes of some of those decisions that are reached by the apex court? Because it's until we tackle it at the root, it will keep repeating, especially in the most recent times, the insecurities and so many other problems that the impact of these conflicting decisions of the apex court has foisted on the society, especially our nation. I beckon on the judges to first of all start to look at, understand, not to look at, but to understand the role they play of men and women in this nation as a whole. It has come to the notice, and not only notice, but it's so apparent that some of the judgments reached by INCURIAM were reached by reason of some factors that are very clear. Some of these justices have political affiliations, so we are faced with political influence in some of the judgments. I'm so sorry that I'm speaking from a very unpopular view, but I have to say the truth. Then some of these judgments are reached as a result of economic factors, which you know, the influence of our dollars and our nairas in this judgment has a way. Some are influenced by result of spouses. We had one of them. I'm so sorry. But that's the truth. Some are judicial philosophies and legal ideologies. Some ethnicism. Yes, man. Some by lack of knowledge, sheer lack of knowledge or misinterpretation of law. Some social-cultural factors. Do you understand? Some religious factors have a lot of influence on these judgments. Then the question is, what do we do? Especially in the most recent time when political influences have been so enormous in our judgments and has thrown the society into chaos, what do we do? I suggest, because of the reason that first of all, we must depoliticize the judiciary. It's very important we depoliticize the judiciary, and we must emphasize the independence. And how do we do that? Independence of judiciary. Judicial appointments, especially to the apex court, should no longer be by political appointments. Let it be by merit and not political appointments. Then we practice a profession where we have seniority at the bar. It's not letting the CJN no longer be by political appointment. It mustn't be the executive appointing the CJN. Let it be the most senior. The most senior becomes the CJN. It's not this one that the most senior, sometimes they have to retire the person prematurely, sometimes they have to, because they want their own person to come in. No, enough is enough. The bar must rise to it, the legal profession must stand to it and make sure things are properly done. We have a part, we have a role to play in this. Nigeria as a nation has been thrown into chaos, and insecurities has permitted the whole place because of these conflicting judgments of the Supreme Court. Until we do something about it, it will remain. But I think time has come for us to rise up as lawyers that has a part to play and do something about it. Thank you so much.
Mrs. Adara came with the fire. All right. Now I'm going to hand over to Onyi Councillor Badejo Okusoya.
This is the problem of being the last person to speak. Everybody has said what you want to say, but before I say anything at all, His Excellency the Governor of Enugu State, Mr. Peter Mba, ably represented by the Honorable Attorney General, Dr. Kingsley Tochi Ude. Thank you, sir, once again for welcoming us so warmly last November when we came to do the very first neck of Mazi Afamusigwe's administration. The chair of the occasion, Honorable Justice J.E. Ekanem of the Enugu Division of the Court of Appeal, I greet you, sir. My lords, justices, and judges of the various courts here present, your worships, senior advocates and senior members of the bar, the guest lecturer, Professor Achara, I beg your pardon, the convener, my brother. Many people don't know that we have a very long history. We go way back. In fact, we've been threatening to write a book together. Maybe one day we'll find the time. Mr. Ikeazo Akaraiwe and his lovely wife, my friend, we met last in Zambia, Livingstone, when we climbed the falls together. Professor Nkiru Akaraiwe, congratulations on that. They're lovely daughters and graceful grandma, aging gracefully. Congratulations, ma. I congratulate you. Distinguished colleagues, ladies and gentlemen, my intervention is going to be more prescriptive than anything else. I define or distinguish conflicting judgments into two broad categories. Those that are knowingly made, which is what several of us have focused on today, and those that are, in my view, unknowingly made because of limitations of our judiciary, if you like. But I'll come back to the ones knowingly made and offer some prescription for that. But for the ones that are unknowingly made, the ones that are innocuously made but have huge negative implications. Last October, I think it was, the Chief Justice of Nigeria, Honorable Justice Tokunbo Kekereekun, at the Court of Appeal conference, she lamented this rise of conflicting judgments and prescribed a very simple solution, which I agree with and I'd like to prescribe here today, that justices, particularly of the appellate courts, the Court of Appeal to be precise, should engage in conferencing. Conferencing so that they discuss and examine the judgment under consideration, the case under consideration, and in that way they get the benefit of one another's experience or knowledge. I would even go a step further to say that such conferencing should not be limited to interdivision or intradivision. It should spread to interdivision. And in order to do that effectively, the judiciary must make good use of technology. Otherwise, how is a case filed in the Sokoto division of the Court of Appeal, for instance, similar to one filed in the Ekiti division of the Court of Appeal, and you have two decisions arising from two different cases, two different appeals, which are similar, but the outcome is different? How do we resolve that kind of thing if we don't have technology to assist in that regard? So I think I agree with my Lord, the Honorable CJN, that conferencing is a solution at the appellate courts level, and that technology should be deployed in order to make that happen. Now, as far as judgments knowingly, conflicting judgments knowingly delivered, well, my solution to that would be one phrase and one phrase alone: political will. We lack the political will in this country to do the right thing. Until we do that, what will then happen is that the appointment procedure will be more, to put it delicately, will be better than what it is. The sanction regime will be effective. So when my lords know, and I say this with the greatest of respect, and in order to borrow Professor Achara's expression, all present company accepted, when there is sanction, then people tend to take dressing, to use a colloquial expression. And then remuneration. Remuneration must be right. My people have a saying in Yoruba, Abuku, I'll say it in English. A cripple is, the load on his head is bent. And then he says, you're looking at the load that is bent, you are not looking down. He's crippled, and that's why the load is bent, right? The basket he's carrying. If our judiciary, members of the judiciary, are not well remunerated, we will continue to have these kinds of situations whereby their lordships, some of their lordships, are tempted to give judgments for the wrong reasons. So all three of them go hand in hand. We must have the political will to appoint the right people to the bench. We must have a sanction regime that works. And when we appoint the right people to the bench, we must pay them well. That's my prescription. On a final note, I would like to say how pleased I am to be in Enugu, and a little bird told me that perhaps Enugu is looking towards hosting something major by next year, well, I hope that I will be here to witness it. Thank you very much.
Thank you very much. I've just been advised that Honorable Justice J.L.C. Okibe. Honorable Justice J.L.C. Okibe. Oh, you're welcome, my lord. Put your hands together, please, Honorable Justice Okibe. I want to remind you also that the Deputy Governor is represented here by Dr. Obioma Chike Okenye. Just want to say that again. Put your hands together, please. Let's do this. We're doing very well. We're doing really well, I'm telling you. You're the greatest audience, I'm telling you. All right. Mr. Chairman, do we open it up now, or do you want to do it now? Or should we open it up first? You're supposed to give your remarks now. Or should we? Oh, no, because you were saying you're good to do. Okay, fine. Okay. Huh? Should yeah, I've been told that. 2 male, 2 female. Yes, okay. So you do yours after that. Right. So now we have question time, contribution time. Oh, come on, sir. That was too quick. Let me make my statement. Thank you. But in any case, here's how it's going to go. Okay. Got a lady there. You're not a lady, are you, sir? I'm looking with 2 ladies at the moment. One lady there. We have the gentleman here. Technically 4. So we have a lady there, a gentleman there, you, sir. I want another lady, please. A lady. A lady? I'm sorry, my glasses are a bit... Oh, no, you're not a lady. I want a lady. All right, please. No, sir. No transgender operations here, sir.
Good afternoon, my lord, the chairman of the occasion, all other protocols duly observed. My name is Nneka Ike. My question is, in view of all that we are saying here in respect to what the court ought to do, especially a high court, for instance, when it is faced with conflicting judgments of a superior court. My question is, what is the place of the provision of the rule of case stated, as I see in all of our high court rules? Is it possible that that can be a solution to some of this problem when the court is faced with a situation where it has 2 or more decisions in respect to the same issues, to make a case stated to the superior court and ask, what do I do in this situation before it finally arrives at a decision? Thank you.
What's the gentleman? Yes. I won't take all the questions together then. Yes.
Permit me to stand on protocols already established. My humble name is K.I. Omuse, Ph.D. My question goes to Leonard Professor R.A.C.E. Achara. In his lecture, he was able to identify the need whereby we have the 3 legs, Professor of Law leading those in classroom, the learned sake leading the litigation, and the bench. Then I appreciate the fact that this workshop is being organized, but I'm of this sincere view that for us to have a pragmatic decision or discussion, we have had a cause to have a retired judge as one of the discussants. I appreciate the fact that the chairman of the occasion is a judge, but he will not be free enough.
Doc, please ask a question, please.
To discuss. No. This is a discussion. And for us to have a realistic discussion, if a retired judge is there, we have been able to drink from his experience. If there is another cause leading to these conflicting judgments.
What is the question, sir?
It's a fact that Law 101, we know we are bound by extra decisis. Is there any other reason that we make a judge to depart?
Is that a question?
Yes.
That's a question. Thank you. Thank you, Doctor. Is there any other reason to make a judge depart? All right. No, not your turn yet, sir. I'll give you a special dispensation when I'm done. I was looking for a lady. My final, a lady, please.
Yes, sir. May I stand on the existing protocol? My question to our resource person is it not possible, because we know that all this long grammar we are speaking is because the corruption, as Adayara stated. Can't we make for independence of judiciary so that the panel that we bring in somebody, if there is independence of judiciary, and then those who are there are those, if any person's name is suggested to be on the bench, then people, lawyers who are persons to whom we know that he is not of good pedigree, then they petition against him so that if the judiciary is independent, even though no one can be given enough money to so that he cannot be corrupt, but if you can put people who have good integrity, can't he stop this idea of having a rule in a court of appeal, Port, having another rule in a court of appeal, Abuja, having one in Sokoto and in Enugu and so on, and then all these things are conflicting, then we are where we are and they made nonsense of the judiciary. Thank you.
Okay, thank you, Mr. Chairman.
Sorry. Oh, yes, there you go.
I want to stand on the existing protocols already established. My name is Joy Manigo. I want to add to what Mrs. Badejo has said. There are problems in this country is lack of political will. It is lack of political will. Because over the years we have spoken about these things, conflicting judgments, and the judges are there still giving the same conflict. Even next year they will still do it. So I think I will make a suggestion. I think the best thing is to find a way to put in our laws sanction for justices who give this conflicting justice, especially those who do it knowingly. I'm not talking of those who do it by, not knowing all the facts, but those who go out of their way to do it for mundane reasons. We know them, they are there in us. We know them, we see them. Something must be done. For instance, today we have a Senate president who didn't stand the primary elections. He's there. And these things are staring us in our faces. The second thing I want to suggest is, we've been talking of these things, political will, political. Let us as lawyers also look at how we will set machinery in motion towards curing these things. Because as long as we keep saying corruption, political will, keep making suggestions how to make this, and we do nothing about it, they will keep staring us at the faces. Next year, the same thing will happen, and on and on like that.
Thank you, ma'am. Thank you. And now the last contribution. So you got red shorts. The very last contribution. I'm really sorry, gentlemen.
Sorry, Mr. Chairman. Please let me just be brief. I want to thank the lecturer, Professor R.A.C.E. Achara, for taking us back to history by bringing up the issue of the kingly judgments, because I think that is the root of our problem. We do have a system where those in authority here believe they have become monarchies. They rule with impunity, and the rule of law has no place. It is a return to this kingly era that is responsible for the malaise we are facing today. Because when you talk about deliberate and non-deliberate INCURIAM decisions, if we want to do the right thing, we can. It's simply that people don't want. Because what is there in a justice of the Supreme Court employing a legal assistant to help do a research to ensure that on any matter, any previous decision could be brought to his knowledge and compared before he writes his judgment? Ditto the justices of the Court of Appeal. It's simply that we have a rule of impunity. People don't care what you do because they have the right. What we are talking about, political will. The political will is there, but it's employed for negative purposes.
Thank you
so much.
Thank you so much. Thank you, thank you, thank you. I'm so sorry. I'm so sorry, but time out on this now. we're out of time. I'm going to hand over to Mr. Attorney General now. Well, okay. Answer some questions, then you finish with. He's going to answer some questions too, I'm sure. Prof. The questions have been asked of you. Okay. We're going to try to keep it as. Yes, the time. Yes. Okay. Yes, sir.
Should I say? Thank you. Much of the things have been comments, and all I can say is I concur. But perhaps to deal with specifics, Silk Tochukwu Madoka suggested, no, the first person is. Am I to deal with also the discussers or just the Q&As? Okay. Okay. Yeah, so Madoka suggested that this rule should be codified, and I think I agree. You know, it's one very simple way of pushing away the issue of caprice in the matter. If it's written in black and white. Okay. The questions, not the ones from questions. Okay, not the discussions. Okay. So, I've been told to answer just the questions and answers. What of using case stated to seek higher court's advice? Actually, it's been tried before, but there are limitations to it. I think it was it R.A.C.E and ACB? There was a Supreme Court authority where case stated, you know, there was an attempt to use the constitutional device of case stated. But it has limitations because the Supreme Court has held that when it's a matter where the Court of Appeal knows the previous judgments have been given on the matter by the Supreme Court, giving guidance on the matter on the Supreme Court, then it's bound to follow it. So the question is still back to the question of which one should the Court of Appeal follow? Because if the rule is still what my Lord Obuagu JSC said, that is the latest judgment of Supreme Court that the Court of Appeal will follow, then what the Supreme Court says is that then you should just follow that one and not disturb us with case stated and giving us more work, you know? So the case stated method is going to be difficult, but I think it was also employed in another case. There was an attempt to bring it up in another case where the issue was on depositions, written statements on oaths. You know, a line of cases from the Court of Appeal will say that written statements on oath, you know, if you make a mistake and state that it was in the office of your lawyer instead of at the registry of the court, that the court will hold that that written statement on oath is defective and therefore not usable. Then another line of Court of Appeal cases says, no, that if you find that such a thing happened, that it does not affect the oath that was taken by the witness in the box. Because what he did in the written statement on oath, if he comes in on the witness box and adopts it, any mistake, any incongruities in it is deemed to have been cleared up. So I think the Supreme Court gave guidance on that matter, I think 2 or 3 years ago, and left it with the principle that, yes, that should not affect or undermine such a written statement of oath. So, yesterday, my learned friend who raised the question of case stated, that's a possibility, but it has limited use. Part of the problem with it is that you're going to be carrying the work carrying the work of the Court of Appeal to the Supreme Court, thereby giving them more work. So they would not really enjoy that suggestion at the Supreme Court because it's giving them more work. Then Dr. Kiyo Wamusi, based on 3 divisions of the profession, judges, advocates, teachers of law, that in a discussion such as this, that we should also have put in a judge, to hear their own side. That I think is a good idea. But, my Akaraiwe is always open to suggestions. So the chairman is, of course, a judge, a very senior judge, perhaps the most senior judge here. So he has had an opportunity to also talk. But I think the organizers, Akaraiwe Associates, will take into consideration your suggestion in future lectures. Dr. Odo, I wasn't quite sure I understood the question, but what I got there was that corruption is at the root of much of our problems, and you can't get any other thing but agreement from me on that matter. Yes, corruption is a large part of our problem, and we ought to address it. Past Secretary Joy Banigo, Mrs. Lack of political will. Yes, I agree also. We have lack of political. As I pointed out, much of the things are contributions, comments, and all I can say is I agree with all of you. Was there any question? My chair, the root of the problem is kingly judgments. Yes, I agree with you. We are going back to kingly judgments once we do not take care of the guardrails against caprice. And why not employ legal assistance for research? I'm not quite sure that it is only by employing legal assistance that this problem will be solved. Because sometimes, and I think they've started doing it, the NJC has made provision for judges, including judges at the High Court, Court of Appeal. They have, budgets for employing legal assistance for them. But then, remember that the pool might not be so broad as to have too much in terms of efficiency. Because sometimes the judge might have a problem of duplication of the work the judge is going to face. Because sometimes you find that the judge does more work than the assistant he employs. and the judge is usually more experienced and already knows more. So I don't think it's really the issue of not knowing the available judgments that have been reported. But sometimes the problem is knowing what superiority rule to apply. That I think is usually at the root of it all. And also, it reduces the problems when the lawyers do some work before coming to court. So if we do our own part and provide the judges with materials, what it will now be left for them to do is to decide what superiority rule applies. When we don't do it, there's a problem. So, but your suggestion is well taken. But what I'm saying is, it's already, I think, already in application. And that's what some of the judges are saying by nodding their heads. These are all the questions so far. Thank you very much.
Thank you very much. Thank you. While we're talking, KC Olemeforo, Chair NBA Ujiri branch, came in. KC, oh, you're welcome, sir. Good to see you. Now, by special demand, request, command, instruction, direction, whatever, we have an engineer here, an engineer Nzerbe, who wishes to make a contribution, ask a question, make a comment, I don't know. Put your hands together, please, for engineer Nzerbe.
Thank you very much, Honorable Chairman and members of the high table, although they say there is no high table here. But I know that the high table does not depend on the height of the table. I have heard somebody say, Justice Oputa, late, he quoted somebody saying that the Supreme Court say we are not infallible. We are not final because we are infallible. Rather, we are infallible because we are final. Now, I see that the major problem is now with the cases at the Supreme Court because it is the final court. And as it is, the lecturer has told us that there are a string of cases, number of cases in every area of law that they have conflicting judgments. And it's a bit difficult now to begin to sort these things out. Now, my suggestion or my question to the high table, is it possible to have Supreme Courts in all the states of the Federation? Now, you see, it may be near impossible to sanitize the judicial system. But you can have a new beginning. And this new beginning, is it possible to legislate it in such a way that every state will have their own Supreme Court and let the matters end there? Thank you very much.
Yes. Oh, well, he's an engineer. Come on now. Okay, now we're moving on with the program. Moving on to the remarks by the guest of honor, Dr. Kingsley Tochi Ude, Honorable Attorney General, who is also here representing the governor. Put your hands together, please, for Attorney General. Yes,
the chairman of today's occasion, my Lord, Honorable Justice J.E. Kanem, JSC. My Lord, the President of the Customary Court of Appeal, Enugu State. My Lords, Judges of Enugu State Judiciary, both serving and retired, learned magistrates here present, distinguished members of the bar, both the inner and the outer bar, particularly now mentioning Ike Akaraiwe, S.A.N., the convener of this event. Please, can we clap for him? Distinguished ladies and gentlemen, first let me bring you greetings from His Excellency, the Governor of Enugu State, Dr. Peter Ndubisimba, who incidentally is a member of the bar, the Enugu Bar, and he acknowledges the support that his colleagues, members of the bar, had given him during the election, during the transition period, and currently. And I believe we are proud of ourselves for what we have identified with. We identified with him, and I believe that we are proud that he's delivering on the promises he had made to us and to Ndi Enugu. If that is a yes, please can we give a round of applause. Let me thank the organizers of this event. Akaraiwe, S.A.N. is a friend and a brother, a source of inspiration to members of the bar. Enugu State government views you as a partner because Enugu State is fast becoming the center of knowledge, sharing, and learning. That, of course, is why we were quick to get the International Conference Center ready. Yes, please, can we give another round of applause? Oh, yes. So because we'll be holding workshops, seminars, conferences, and I believe it will host the annual conference of the Nigerian Bar Association by next year. So let me say that the topic of today's lecture is not just about lawyers, the academic, the practitioners and judges, but it also involves the totality of our society. So our approaches to this very important issue, which has actually become an existential problem, should certainly go beyond the legal profession. We should say a yes to even legislative solution to that issue. So if matters of procedure that relate to appeals that lie as of right and by leave can be enshrined in the Constitution, I believe rules regarding which judgment should be followed, whether the most recent or the earliest in time that has not been overruled, I believe it could be enshrined in the Constitution. And another way also of doing that would certainly be even the rules of courts, the rules of the Supreme Court, the rules of procedure of the Supreme Court could also capture that while we wait for a larger legislative approach to that. And certainly because this is a matter that involves various causes, we would also have to leverage all the remedies that have been presented here: recruitment of judicial officers, knowledge learning and sharing in our institutions of higher learning, even the involvement of the bar in all of this. So it's all hands on deck. And let me say it's also all hands on deck as it relates to governance in Enugu State. Especially, this is our own. The governor is a lawyer, the deputy governor is a lawyer, the chief of staff is a lawyer, the honorable attorney general is a lawyer. We have many lawyers here. So, and it has become something that one could say precedent that lawyers do well in governance. So let all hands be on deck. It's our thing. The success that we've recorded so far is because of the support of Ndi Enugu, including the members of the bar. So let's even extend it more. Let's extend it more. Let me say that we are happy to entertain suggestions on how we can improve on our performance, not just in the justice sector, but across. Because one way or the other, it affects everyone. It affects all of us. And you know that we have provided ways of reaching, even if you can't reach directly, you can reach through virtual means, you can reach through other sources like emails that have been provided across the internet. Enugu State governance is actually out there in the internet. You can access any MDA, just as we're doing automation of our justice sector. So let me also use this opportunity to announce that at the moment we are doing a law revision of the laws, the revised laws of Enugu State of Nigeria 2004. Yes, we've already sent a bill to the House of Assembly for appointment of a law revisor and the powers of the law revisor. So it's an opportunity for all of us, any areas of our legislation, of our laws, that you feel should get attention either for correction or proper amendment. Please, we're happy to receive our views. Of course, just as we said, it's our state, it's our system, and it involves and affects everyone. So on that note that I thank us all. Of course, you can see that it's so important to us that this is happening. That is why we're here up to the end of this event. Thank you very much, and God bless us.
We can do better for His Excellency, the working governor. We are blessed with you, Your Excellency. Thank you. Ladies and gentlemen, you know, a good beginning should be marked with a good ending too. And we're in item number 8, closing remarks by the chairman of this august occasion, Honorable Justice J.E. Ekanem, JCA.
Thank you very much.
My Lord.
Sorry, I have chosen to stand so that those at the back will not say they did not see me. I'm not saying anything about my physical attributes. So thank you very much for the patience you have shown to stay till the very end. It has been worth the while. I'm sure you will agree with me. I have been enlightened, I have learned, and I thank the guest lecturer, Professor Achara, for the incisive lecture. Thank you so very much. I want to make one request of the Prof and probably the organizers of the lecture, that this be reduced into writing, and that whether by electronic means or by hard copy, we should have copies of this lecture. It will really help us. Thank you very much. I thank also the organizers of the lecture. I will not delay you any further with just one point or two. I've always believed, because issues were raised about judges, etc. I've always believed and stand on that belief that the most important aspect of the independence of the judiciary is not what you have in the Constitution, it's the independence of the individual judge. It is between you, not man, not angels, between you and God. Because I believe there's a day of accounting. No man is qualified to judge another man. But God has, in his wisdom, appointed some persons to judge others. So it is a very important and at the same time dangerous position, because you give account at the end of the day. Finally, there is too much work for the Supreme Court and the Court of Appeal. Not all appeals should rise up to the Court of Appeal or the Supreme Court. It should stop somewhere. I think with the reduction of volume of work, you will also have less conflicting decisions. So I thank you so much for being here. And the organizers, I pray that God will take you back home safely. Thank you so much. God bless you.
Put your hands together, please. Keep clapping. Keep clapping. Keep clapping. Thank you. Thank you very much. And now, oh yes, the vote of thanks by our chief host, the convener, the one that called us out today and gave us this wonderful feast of learning, knowledge, and interaction. Akaraiwe, S.A.N. Put your hands together, please. It might not look it, right? But it's older than me. Can you imagine that? Just a few months, okay?
Thank you. Your Excellency, my Lord, the Chairman, my Lords, distinguished ladies and gentlemen, I am so deeply honored. We are honored by the fact that the governor of the state came here at the beginning of this event, and he's here up till the end of the event. In spite of the fact that there is an EXCO meeting slated for today, the Honorable the Attorney General has insisted on staying to the end. And we are most obliged, we are most impressed, and it shows that they're interested in hearing so they can improve the structure. You know, I used to complain when you attend the annual general conference of the NBA. On the first day of the conference, maybe the president or the governor or the attorney general is to declare the conference open. He comes in late, declares the conference open, and doesn't return to his seat, goes out shaking hands with everybody, and then he goes out.
So they do not have the opportunity to listen and get the feedback of the people. So I used to complain about it, but His Excellency the Governor, duly represented by a barman extraordinary, Dr. Ude, has changed the narrative, start to finish. More exciting is the fact that the Deputy Governor is here also, ably represented by Dr. Okenwa. Obioma Okenyi, oh, forgive me for, for changing your surname. The Deputy Governor is here. He's a lawyer too, Ifeanyi Osai. He's here and represented by Dr. Obioma Okenyi. The Lord bless you. This has been wonderfully attended. But how can I single out the hierarchy of the states? If they came here and this hall was empty, the program has failed ab initio. Is that not so? So you are the most important and you are here, members of the bar. The bench is here. The Enugu State Judiciary is ably represented here. The most senior judge of the judiciary after the chief judge is here, Honorable Justice Onovo, and the president of the customary Court of Appeal was here throughout the lecture. And my lords are all here. You know, Enugu State Judiciary has a plethora of PhDs on the bench. And those who don't have the PhD have so much experience that it is as good as a PhD. Thank you very much. My big brother, Honorable Justice Nwobodo, you know, when I lost my father-in-law, Justice Nwobodo is always with me. He's in my village, he's in my wife's village whenever anything happens. But that doesn't mean that I win all the cases in his courts. I've lost a few. Friendship does not get up to the job. So thank you so much, my lords, Justice Namani, Justice Oboabo, Justice Ani, my classmates and callmates and sisters who I don't win every case in their courts. I've lost a case in Justice Ngozika, Orji's court. Never mind that we're classmates, and Justice Okibe. Thank you very much. We are most obliged. God bless you all. The magistracy, you are fantastic. With your great chairman, he told me he has a judgment to deliver. He will leave at 12. Yes, CKC Edu is gone to deliver a judgment. Enugu State has some of the best magistrates you can find anywhere in the country. Thank you very much. And I want to intercede on behalf of them, now that the governor is here, that let us do something to improve the conditions of service of the magistracy in Enugu State. Especially their courts. They need courts and they need vehicles. They need to have cars. I am your advocate. Many years ago, as chairman of the bar, I made an advocacy in the presence of Governor Chime. I said, your magistrates are riding on Okada. That we lawyers are going to court and the magistrates are sitting on the back of Okada. And Chime was there. That was the valedictory session in honor of Justice Elvis Ahanonu. And within 1 month, the magistrates all had vehicles. So I won't say within 1 month. I won't say within 1 month. But before the end of the year, I know something will happen. Thank you. Thank you so much. The chair of the occasion left your busy schedule. Honorable Justice J.E. Ekanem, JCA. You see, my lord, you are going to the Supreme Court. Because when the Attorney General was speaking last, how many of you noticed that he called him Ekanem JSC? You noticed it? It's a prophecy, and I know that the man is a prophet. He is a prophet. Some years ago, I was invited to lecture, give a lecture to the judges of the Enugu State High Court, and I mistakenly referred to Honorable Justice Obuenya. What's his other name? Obande Obuenya. I referred to him as JSC, where he's now JSC. So, soon and very soon, Soon and very soon. Not because we are sentimental, but because it's really good. He's good at his job. The discussants, what a quality resource we had. Ifeoma Adara, I didn't know she was a passionate speaker like that. She's been wanting to be a judge. She was my head of chambers for years, and I do hope it will come to pass. Fidelis Mbaluga, an SAN who deserves to be SAN. Thank you very, very much. And Tochukwu is gone, but that's another SAN who became SAN before he was made SAN. By the quality of his practice. Thank you very much. All the way from Lagos this morning, Oyikon Sola Badejo Okusonya. I know you are clapping because I pronounced the name well. She came in from Lagos this morning to discuss. We are so honored to have you here. She said a little bird told her that Enugu will be hosting something next year, or wants to host something next year. And then the Honorable Attorney General mentioned that we are hoping to host, did he mention it or is my imagination? The Annual General Conference of the NBA. Did he mention it? Okay. The way a little bird told you something, a little bird told me that you are likely to contest the presidency of the NBA. These little birds go about gossiping. I have known Onyekon Sola for years, and I do not mean flattery when I say it's time to have a second female president of the NBA. May it please the Most High to give it to you. And if that will happen, then it will be in Enugu that the next election, the next executive will be inaugurated. So, all roads lead to Enugu next year. We are going to host the AGC next year. Warn everybody, including your Lagos, they should wait. Because we have not hosted for 23 years. You people host every other year now, so allow us host next year. So, thank you very much for coming. And thank you for your contributions. I'm leaving the best for the last. Is it last for the best? Okay. All right. Professor Richard Amarachukwu. Or is it Amarachi? Amarachukwu. I don't know the C, but I know that the E is Ezekwesili. Chukwuemeka. Professor Richard Amarachukwu Chukwuemeka Ezekwesili Achara. So today you now know R.A.C.E is an exceptionally gifted young man. I call him young because I'm older than him by 4 or 5 years. Exceptionally gifted man, R.A.C.E. And he's a blessing to the bar and the bench. When he was about 32 or so, he became or 34, he became the chairman of the bar, ushering in a new regime of leadership of the bar. And what a successful chairman he was. I was financial secretary under him, and I'm his senior at the bar. His vice chair, Antoniani, he's senior at the bar. His entire ESCO were basically his seniors at the bar. Well, we worked happily under him. I think that if we know what we are doing, a person like Professor Achara should be senior advocate of Nigeria. He should be invited. He should be invited by the CJN, the way a certain CJN invited Gani Fawemi to apply for the rank, the way another CJN invited Femi Falana to apply for the rank, Achara should be invited to apply for the rank. And the year he's given the rank, the moment there's a vacancy in the Supreme Court for the Southeast, he should be appointed Justice of the Supreme Court. I'm not flattering him. After all, Professor Elias was Dean of the Faculty of Law, University of Lagos, and moved from the deanship not to the Supreme Court, but was Chief Justice of Nigeria. Okay, he moved from the deanship to Attorney General of the Federation. Am I right? And then from there to CJN, not Justice of the Supreme Court. From lecturer to dean, to Attorney General to Chief Justice of the country. So once upon a time, Nigeria was working quite flexibly, and I don't see why Achara. And I know that he will deliver. He will deliver. If Achara goes to the Supreme Court anyway, we shall have dissenting judgments every week. I want to thank the lawyers and officers of my chambers. They are often overlooked. I didn't organize this. In fact, I came back into Enugu yesterday. My head of chambers, Chinelo Chijioke, called 2005. What a fantastic mobilizer of men and resources. My former head of chambers, Joy Nani, where is she? Yeah, there she is. I thank you all. AGKM Oji, head of litigation. Where is the AGKM? Please wave your hand. Head of litigation in my office. Ogenefego Udu, wave your hands. Mrs. Anne Gonu. Chidera Idakwo. Have I missed out anybody? The other one is on maternity leave. So I'm so grateful. Then the non-lawyer staff, Mr. Chinedu Chagu, yes. Ezine Nwachuku, Alice Edward. I can go on and on and on. Phoebe, Amondi, and everybody, thank you very much. This success is to you, and we have had a most successful outing. Somebody may ask, why is Ikazo doing this? Why is he organizing this? This is the 4th year now. By the grace of God, we are 40 years at the bar this year. And you come to a point, you are driven, well, I said it, but I dare not say it too loud where Dr. E.J. Okereke is. Because E.J. Okereke was called to the bar 2 years before I was born. 2 years before I was born, he was called to the bar. But I'm not going to tell you the year, so you won't know my age. You know the year he will. So when I say we are 40 years at the bar this year, I'm saying it with all humility. Because I have my seniors here. Peter Eze is my senior. The master of ceremony is my senior. Where is he? The Dr. Eyoye. But he's my senior at the bar. Himself and Peter are called in the same year. So maybe you people will reintroduce yourselves. You've put on weight now since you left law school. You don't recognize yourselves anymore. But we are driven by a desire to add value to the knowledge base of the bar and bench. It's not because I want to run for president of NBA. Like somebody who was asking me, this thing you are doing, do you want to run for president? I will not run. If you give me, I won't take. I won't take it, I will not run it. I'm here totally altruistic reasons to add value to the bar and the bench. We decided to start doing annual lectures as some jurisdictions, lawyers do it. The 1 week of law week in December every year is not enough. We need to have something every 3 months. Look at, we didn't import Professor Achara from the UK. He's here with us, goes to court with us in this town. And look at the resource he has. We have resources that are unspoken. They are here. They have so much to offer. Now, everybody is living here richer than when you came in. You are richer because you listen to him. And the chair, my Lord, the chair requested for the lecture to be distributed. Thankfully, it is recorded. And you have my word. We are going to transcribe it, send to him to edit, and then we will distribute it. Soft copies, hard copies. In fact, we are going to publish it as a booklet. We're going to do that. So I really thank you all. Let the vote of thanks not be longer than the lecture. I really thank all of you. I thank my mother. She brought me to the world, and she is always here by me. She's seated there. There is a statement that people make that is become trite, that become so worn out statement, where they say, my jewel of inestimable value. But when I describe my wife as that, I'm not just saying it, she is my jewel of inestimable value. There she is. And of my very few children, my 6 few children, very few, 2 of them are here. My firstborn, Dr. Blossom, her face is covered, but you can wave. She's a medical doctor like her mother. And I have 4 daughters. So the first of the girls and the first of the children, the 4th of the girls is here. Some, please now, rise up, let them see your face now. You're all very welcome. And thank you for all the support that you give me. I thank you all, and I assure you all that we will continue this as God helps us to continue this. And hopefully, these interactions will produce a more excellent bar and bench. Thank you very much. Thank you. Thank you. Thank you. Yes. We have a few gifts. We have a few gifts for our resources, and so my head of chambers is distributing them, so that's fine. We have customized diaries for this event, so they'll be distributed to the bench, to the magistracy, and to the senior lawyers. Thank you very much.
Whispering, I want to pray. After. Okay. Yeah, we're more or less done now, but I remember pleading with you to please fill out the forms. Has that been done? Gentlemen, ladies, Doc, have you filled out your form? I'm looking at Doc, he's looking at me. Fill out the forms. Okay, right, thank you. Please. The forms, yes. Let me go to the forms. What is this, my God? The forms. No worries, sir. Let's not take this too far. Thank you. Thank you very much. There's also, oh, yes, Maria. Please, just go around and, Please, you get your forms ready. Someone's going to come and put them from you. The forms, please. Thank you. Okay, whispering. Another announcement, please. The certificates are ready. Certificates of attendance are ready. So please, once we pray and close the meeting, please stay seated and the names will be called out and the certificates presented. Now, for those whose certificates are not available today, they'll be made available at the NBA meeting. Thank you very much. And yes, there's also, wow, that's going to be outside, I imagine. Yes. After we've received our certificates, we're going to go out there to take some photographs, group photographs. We want to take capture as many of the people here as well at this program today. So please, thank you so much. You've been wonderful, you've been kind, you've been engaging, you've been involved, you've been present. Thank you very much. And I'm sorry I didn't call you. You give me a look. You're looking at me funny. You. I called very much. Doctor, where's it? Dr. Chijikagbo is he here? Oh, okay. You're welcome, sir. Sorry, I was meant to call you earlier. I forgot. Right. We'll call Pastor. What's up? I want to go and pray. I'd like to crave the indulgence of Justice Sisiani to please close the meeting for us in prayer. Thank you, man. I'm so sorry, man, but you know, I know nobody told you this. They didn't tell me either. Thank you, man. Thank you.
In Jesus' name, in the mighty name of Jesus, our dear Father and our God, King of glory, King of kings, Lord of lords. Father, we give you thanks and praise for a day like this. We thank you for the lives of each and every one of us here. We thank you for the work we do. Thank you for our families. Thank you for the convener of this lecture, Akaraiwe S.A.N. and his lovely family. Thank you, Lord, for the paper presenter, the lecturer, Professor R.A.C.E. Achara. Thank you for all the lawyers here present and every other person here. Father, accept our thanks in the name of Jesus. Father, we thank you for making this program a glorious one, for making it to go well. Thank you for bringing all of us from far and near. Father, we have come to the end of the program. Some people will be traveling. Some people will just be going home. Some will be going to their offices. Father, I will ask for your ever-abiding presence. As we go, may we go with your glory. Father, to you be all the glory, honor, thanksgiving, adoration in the mighty name of Jesus. Shall we share the grace? Grace of our Lord Jesus Christ, the love of God, and the sweet fellowship of the Holy Spirit be with us now and forevermore. Amen. Surely, goodness and mercy shall follow us all the days of our lives, and we shall dwell in the house of the Lord forever and ever. Amen.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we contest gain. To hang unto our children a banner without stain. O God of all creation,
Thank you very much. Please be seated. Please be seated. The Governor, the Attorney General, the Deputy Governor, Mr. Chairman, the discussants, please. My Lord Judges, the Lord Justices, please, some pictures outside. My Lord, some pictures outside. We're going to take some pictures outside. I think the rest of it now is
Please, the group photograph before His Excellency leaves. Group photograph outside, please. If you know you're a participant, please, group photograph.
Said I thought I was the only one. Say not me, you call your number one. I thought I was the one. Why did you lead me on so long? And she said to me, did you even notice that I don't call you anymore? Did you even notice that I don't pick up your calls? See Shoko hold me down. Before I know, that's all she said to me. Oh, Chike,